Compromise.
Yes.
Compromise. On the basis of the settlement between the parties, between the petitioners, amongst the petition, call for the scanned copy of the trial court record. Mr. Jita and SLPD appears for the state. Next paragraph. Pending production of the trial court records. The further proceedings of GR case number 203 of 2011 before the learned Chief Judicial Magistrate, Capital Complex, UP, shall remain state till returnable. No, shall remain state. List after 4 weeks.
Obliged. Much obliged.
You have
Lordship. Lordship,
you
here
are sure to be transferred on promotion.
promotion, Lordship, I've already taken in charge as a branch manager in a scale of 3 in the Pasigad, which I have annexed, Lordship. I'll straight. That
Where's
is
the impute transfer?
impune transport is page 19, Lordship. That's annexure 5.
19.
Here by a common transfer, 35 number of branch manager were transferred. And this transfer was issued by the general manager, Opera and admin.
Operation and administration.
Yes, operation.
And who is the transferring authority?
Transfer authority is the chairman, Lordship. As per the guidelines by the Arunachal Pradesh Rural Bank.
Where it is?
Lordship, I'll straight away take with to that page 30, Lordship. That is the page 30, Lordship.
Yes.
May I read, Lordship? Norm for transfer of officer of Group A. Your Honor, Lordship, here I come under Group A. I'm in scale number 3. Lord. Chairman is the competent authority for effecting the transfer of officer. That is scale 2.
You are Group A.
I come under scale 3, Lordship.
Or are you Group A or not?
Group A, Lordship.
Group A.
Group A, Lordship. Seems like I've been promoted to scale 3, Lordship.
Scale 2 and
Above.
General manager 1 is the company authority for officer. Scale 1. You are in scale 3.
Yes, Lordship.
What is your post? Manager.
Manager. It's scale 3.
What is the post?
Yes, Lordship.
It's a manager or what?
It's managerial management.
Designation of the post.
It's it's called a full branch manager in a common language will say.
Where do you get it? Where do you get it?
Lordship, that is the promotion that is in page 17, Lordship, annexure 3. That where it says that I'm scale 3, Lordship.
That's why I'm asking, what is your designation?
Is management grade scale 3, Lordship.
Middle management.
Grade middle management grade 3.
Otherwise, you are
Lordship, I was on scale 2, then I've been promoted to scale 3.
You are middle management grade.
Yes, Lordship.
In middle management, but as a manager.
As a manager.
So your designation would be is middle management grade or what manager?
It's Lordship. They say it's a branch manager. Once, like, if you come to grade 3, you get the full in charge of a branch manager. So here, Lordship, I've been promoted to scale 3 from scale 2. And accordingly, Lordship, I've taken the charge on 2023. That is on 10/2023. As per the guidelines of them, Lordship, it says it's 3 years. After 3 years, only my transfer can be done, and the transfer authority is the chairman, who is the competent authority. But here, Lordship, in the impune transfer order, The transfer order has been issued by the general manager.
Where it is? Where it says 3 years?
Lordship, that's coming to page 30, Lordship. That is paragraph 4, Lordship,
3 years.
serial
all
number 4.
Centers except
All officers should
a different
normally be
center
transferred
where
every
a
3 years.
center will be formed. Yours is not the difficult centers.
Yes, no.
Yes. How do you, where is the transfer?
Transfer
If you transfer.
in tune transport. In tune transport is Lordship, page 19
21.
annexure 5. And
21.
this is Lordship, I mean, page 20, the serial number 12.
What is this page 21?
Page 21 is Lordship, it's a release order saying that I have to be released by 15/6 of 2024 from the branch and reported to the my place of posting on 17/6 of 2024. That is in
What
the
is your name?
page or 17, Lordship, serial number 17 on page 21.
Mr.
Lordship, we have not endorsed for the matter, actually, Lordship. The Titaba is Learned Counsel. He's for trial court, Lordship.
So let it be in trial court. It's good.
And Lordship, in different, in the same
Okay. Mr.
V. Jamo.
Huh?
V. Jamo.
Jamo, learned counsel for the petitioner. Just wait. Mr. By filing this red petition, the petitioner has put to challenge the transfer and posting order dated 31/05/2014. Whereby as many as 17 or how many?
Lordship, 35.
35 officials, public officers have been transferred and posted in different places.
So Dapur is from Pasivat.
Transfer and posting, issued by the transfer and posting order that is so and so issued by the general manager within bracket OPS, page 19, and admin bracket close of what is this? Arunachal Pradesh
Rural Bank.
Rural Bank. Rural Bank, whereby as many as 35 officers have been transferred and posted in a different places. Mr. The petitioner is sought to be transferred from Pasigat to Daporija. Issue notice returnable by 4 weeks. MS, you are appearing on behalf of
Titaba,
MS Titaba. MS, your name?
N. Hondik.
Learned Counsel appears and accepted on behalf of MSN on appears appearing for Mr. Titaba, Learned Standing Counsel for Arunachal Pradesh Rural Bank, accepts notice on behalf of the respondent number 1 and 2. List of no formalness in this respondent number 2 over extra copy so and so, Then Petitioners to next para. Take steps for service of response number 3. Barrister post. With 80. Within 2 days. Next para. Pardon, interim prayer. Next para. Considering that the petitioner has been sought to be transferred by an order passed by the authority not competent in terms of the what is there in terms of the Arunachal Pradesh Rural Bank transfer policy and he has yet to complete this normal tenure. But it is provided that till the returnable debt, the impugn order that is 31/05/2024. That's all.
Yes, Lordship.
Shall not be given effect to. This after 4 weeks.
Yes. Deeply obliged.
You tell him that on the ground of incompetent, the authority not competent has passed the issue, therefore, stay.
Your Lordship, CD was called for, Your Lordship. We have received the CD. And the issue, Your Lordship, I pointed out on the section 79 of the JJV Act.
Hmm.
So far as the statement of the victims are concerned, Your Lordship, they have clearly stated, Your Lordship. They been brought by the mother and one more person is there. Your Lordship. And for that, in exchange, they have taken some consideration also.
So,
So, Your Lordship, so I have objection on that only, Your Lordship, because the interest of the minor has to be looked into. Because if we see the section 79, then in that case, the mother who given the custody of the minor to the for a household purpose to work as a household person of the accused, she is also become the accused in this case, Your Lordship. So whether now, since she become the accused of the case, whether she can enter into agreement on behalf of their children or not, Your Lordship, this is the issue.
Your Honor, that's
the mother
Yes, Your Lordship.
who has
Yes.
signed the agreement.
Yes, Your Lordship.
Hmm?
Yes, Your Lordship. Mother name is Srimati Miniki Chakma. It's in page number 27, Your Lordship. The thumb impression, right thumb impression of the mother, Your Lordship. And as for the 161 statement, Your Lordship, the victim, they have disclosed one more name, Chiki Chakma. They both brought them to the place of household of this present accused, Your Lordship.
Well, this investigation is over.
Investigation, Your Lordship, investigation not over. It's almost complete, Your Lordship. Everything is complete, Your Lordship, almost done. It's now yet to file the charge sheet, perhaps. Your Lordship. If Your Lordship allow, I will read out the statement, Your Lordship.
Hmm?
If Your Lordship allow, I will read out the statement of the minor, Your Lordship.
Yes.
Okay. On being examined, he stated on so and so, I was brought to Jarampur by Dayun to work as household in the house of Tadar Kasung by my mother and Chico Chakma. Agreement was done wherein I accepted to work for him for a period of 1 year. He paid 30,000 as advance for 6 months. Since then, I have been working under them as a house help. Madam used to beat me, scold me. Few months back, I found one gold chain of 5 notes of mobile from the house. I sold up 4 mobile up to scrap dealer for 400 rupees and one mobile I kept in Jerampur, and I gave the gold chain to one person by the name Johnny in Lekki, and I don't know what he has done with it. Due to this incident, Madam called my mother to come and discuss. On 4th March, my mother and Chiko Chakma came to house of Tadar Amak, but she was insulted my mother and she was asked to leave the house. On 5th March 2024, I overheard Madam calling Achi Priya and saying Darao ye loko and left for Guwahati. On the same night, Achi Priya came to house and started beating me and my mother with iron rod. Chico was also present. Chico, one of the co-accused, was also present at the scene. A day later, mother was taken to hospital, but she was unable to walk, so I carried her in my bag. In the hospital, I received a call from Madam Tadak Amak, wherein she warned me not to file complaint at PS. On 11 March 2024, CWC team, along with police personnel, rescue us and shelter us at Oju Mission, Naharlagan. And one more statement, Your Lordship. On being examined, he stated that I was brought to Naharlagan from Dayon to work as household in the house of Tadar Kasung, my mother and Chico Chakma. Chico Chakma is not the party in this case, Your Lordship. After 1 month, since Anil started working, since then I have been working under them as a house help. Madam used to beat me, scold me. In the month of October 23, when I asked Madam to let me go home, she poured hot water on my face. On 4th March 24, my mother and Chico Chakma came to house of Tadar Amak, but she was insulted by Madam and she was asked to leave the house. On 5th March 24, I overheard Madam calling Achi Priyan and saying, Darao ye loko, that is threatened them and left for Guwahati. On the night, Achi so and so came to house and started assaulting me, my brother Anil Kanti, and my mother with iron rod. Chico was also present at the scene. A day later, mother was taken to hospital, but she was unable to walk, so I carried her in the back and the hospital. I received a call from Madam, wherein she warned me not to file complaints. Same, Your Lordship. So, Your Lordship, as per the statement, the Chico Chakma should also be the one of the party because she accompany the mother by the time when they brought to the house of the present accused, Your Lordship.
Your Honor, Chico Chakma is just a middle sister of Miss Minika Chakma. And Your Honor, that Chico Chakma has been staying with the accused person since 2 years. And Monica Chakma, the complainant, she worked in someone's house. And Your Honor, that the child whose age is 13 years old, they are.
What about this section 75 and 79 of
Yes, Your Honor, I'm coming to
JJ?
that. I'm coming to that, Your Honor. That this child, they are living very destitute life, Your Honor. Even that the child father has expired and they do not have house. So this Chiku
No,
Chakma,
since your petition has been on the basis of compromise,
yes, Your Honor.
how can this be? Can this such type of offense can be
Your Honor, that the
compromised?
even more severe case have
Is it
been, Your Honor, passed by the
child
Honorable
labor
High Court. This is the
involving
punishment
minors?
is up to 5 years. And if we go in detail, Your Honor, that the child, he has been staying, that one 17 years child has been staying with the accused person, and he is the immediate elder brother of this child, that the Vijay Chakma, whose age is 13 years old. He do not have any place to stay at his own place also. Therefore, Your Honor, this Chico Chakma, she has brought the 13 years old child to brought with her, and in the place of that the occurrence, Your Honor, that the accused in the absence of one of the accused person, incidents was happened. However, Your Honor, that the important thing is that, Your Honor, that the mother, she has brought the child into the house of alleged accused person, and even mother do not have the place to stay. They have been living very destitute life. Your Honor, if this honorable court does not invoke this 482 of CRPC, this all the Chakma families, they will be also, Your Honor, in a very trouble cases stage, Your Honor. And even, Your Honor, this accused person and that they are staying now, they have been resolved and they are living peaceful
Paid 1,50,000
for medical treatment.
shown to be. Then it's an admission. You have
No, Your Honor.
you have caused an injury. 1,50,000.
That is
Medical
for your
expenses.
medical expenses, Your Honor. And Your Honor, this regarding this
You want to
Section-
try somewhere else?
50, 76 and 79, even in true sense, this does not attract, Your Honor.
75 and 79.
Yes, this
Why?
does not attract, Your Honor.
Why?
Because Your Honor, that the accused, they have not brought the child from that their place to here. And secondly, that there was no any cruelty on part of accused person. Accused person, she is staying with her husband at the posted place at Bordumsa in Changlang district. And she was not present in the place of occurrence also. Therefore, she has been made accused in this case, Your Honor. And she is completely, Your Honor, one of the accused is completely innocent in this case. And other side that the Chagma, they are also very destitute, Your Honor. If church, they are also living in very destitute situation, very poor condition, Your Honor. If this honor,
There is the reason you have taken advantage, some of the accused,
no, Your Honor.
taking the advantage of the
Ah.
destitution,
No, Your Honor.
helplessness. You have
This
entered
child-
into an agreement.
This child was brought to the home just
Sir,
1 week before.
Sir, this court is not convinced. If you want to try next week. Heard Mr. A. Bodo,
Yes,
London
sir.
Council for and also heard Mr. Theatre, London Additional PP for the state. Come on. Considering that the offense involves Section 14 of Child Labor Act. Section 14.
Section 14, 79 and 75 of JJB.
Yes,
14 is child labor.
One page.
Yes. Your Lordship, under section
40,
343.
Refer from Section 343, 343, 326, 370 of IPC. The offense list invoke Section 14 of Child Labor within bracket Prohibition and Regulation Act bracket Act 1986 base 21. You check it. And also Section 75, 79, 75 and 79 of Juvenile Justice Care and Protection of Children within bracket clause Act 2015. Come on. The learned counsel for the petitioner. So, for a week's time to submission on such make his further submission. Considering above, come on, let the matter be listed after a week. You had to, his objection is on that. You try to satisfy.
Yes, Your
But I am not
Your Honor,
satisfied today.
there is one provision that Section 2 of the Child Labor Act, definition child.
Yes, you
But
make an
who-
argument on that.
Your Lordship, CD may be written.
No. Next week, the learned additional PP to retain the CD.
Okay. Your Lordship. Deeply obliged.
Yes.
But in this case, rejoinder was required to be filed. We are filing it today. It is in the process of filing. So meetings are that way complete.
What is the challenge?
Challenges with regard to certain conditions that have been put in the NIT.
Can you challenge that?
But the ground of.
Normally terms, it is settled law.
Well, the ground is that, my lord, the conditions which have been put, they are so restrictive in nature that except for certain entities, nobody can come. There, the qualifying marks have been raised to the standard of 90. Now,
Is it so?
if your lordship will kindly see the.
Mala this thing mala not only state of Arunachal Pradesh but other state also mala they are applying the same terms and conditions. Mala
No.
this we borrowed it from the Meghalaya and some other
It's okay,
state.
it's okay. It may be, this terms may be applied in some other state also, but it's not been put to challenge. It's not before us. If they can show that it is so restrictive and
May not be,
to make and so I mean so tailor-made to suit somebody.
And in our.
If they can establish.
Well, I can-
Otherwise, normally
I can
terms of the tender,
yes mala. provided there is discriminatory, provided. Now only Malot, what they can say in commercial transaction, there shouldn't be any discrimination, Malot. Now,
Malot, in
the terms and conditions which we have put, Malot, this does not discriminate anybody, Malot.
Now, in
It is
the
for all, for all,
rejoinder
Malot.
that we are filing today, my lord, we have also enclosed the similar tender quoted by the government of Assam.
So you're supposed to appraise this court the basis of incorporation
Yes.
of clause 5 and 8.
Yes, Malot, we have said in our affidavit,
Okay,
Malot.
you have filed the affidavit. You want,
Yes,
They have said in the affidavit.
you want to file affidavit.
Yes, our
Re-
rejoinder is ready.
reply,
my
my
lord.
Okay.
Just after some time it will be over. And in the rejoinder, my lord, we have also enclosed the similar tender quoted by the state of Assam. They are saying that they are.
Mr. S. Datta, senior counsel assisted by MS. Counsel for the petition and also Mr. Arichan Abdullah, additional. Additional General for the state. Who submits that? No, Mr. S. Datta, senior counsel submits that. You'd be filing the affidavit in reply during the course of the day. Consider the above. In view of that. No. During the course of the day. Considering above. Let this matter be listed after
16th of July.
Malot, 16th of July, Malot, can it be little bit of observation, Malot? Endeavors shall be made for final disposal
Yes,
because interim order is operating against us, Malot.
Yes.
Why not then next week?
Well, some difficulty, my lord, he also knows, my lord, I may not be.
Malot,
Some personal.
father obligation is there, Malot, I can understand.
That's all, my lord.
Let the matter be listed on 16/07/2020.
For admission hearing, Malot.
Considering that the matter relates to tender.
Yes, Malot, it's a supply of, Malot,
No, matter relates to supply of what?
Supply
It's,
of multi-grain
millet
based
biscuits,
food
my
item.
lord.
Multi-grain based food
Biscuit.
item.
Where it is?
Multi-grain based. food
Malot,
item.
page 23, Malot, your lordship will find, Malot. Petition, Malot, page 23.
Supply of multi-based disputes.
Yes,
It is multi-based biscuits.
Millet-based biscuits fortified with vitamins.
Millet, sorry.
Millet.
Millet-based biscuits fortified with vitamins and
and minerals.
And never shall be made to dispose of the matter on the next date. The
Malot,
next date fixed.
Yes.
oblige, Malot.
Obliged.
So, Volunteers, can it be disposed of today?
I hope so,
Immediate
Lordship.
disposal.
It need early discussion.
Lordship, just to make it clearer, I have compiled a list
Yes.
showing the dates, showing the pages. Number one, this is the discrepancy in the counter affidavit, which I pointed. If I go page by page, it may take a long time. So therefore, A is signatures of official witness in the MOU. There are two set of witnesses shown. One is Engineer Nangrambai, and the pages I have mentioned. And I have said that this is signature in these pages have been forged. If your lordship pleases, we can go through page by page. Otherwise, if
It's okay, we'll not examine all this.
lordship,
We'll take note that you have
I have not given consent.
stated that these documents in the counter affidavit
Yes,
are forged,
yes,
cannot be relied.
yes. Also, lordship, I would like to point out one very important thing, lordship. Lordship has seen the PMGSY guidelines. According to the guidelines, the central government is not giving funds, but the state can evolve its own mechanism. So this would imply that without consent, it cannot be taken. If they want to compensate, they compensate. If they come to an agreement, they come to an agreement. That is the mechanism that they have developed. Now, as per the guidelines, before preparation of the DPR, they're supposed to settle these issues. It is specifically mentioned in the guidelines that in the DPR, land availability certificate should be enclosed. Number one. Number two, an informal transact what should be done before, and these documents should be enclosed in the DPR. Now, the documents
First is as
For-
per guideline,
as per guidelines,
PMJS guideline.
PMJSY guidelines, which they are
Regu-
following in these cases. I would specifically mention 6.12 and 6.13 at page 155 of the writ petition. For the sake of brevity, I'm not reading this out because I have read it out day before yesterday. It is said that before
What is the guideline?
the
What is
PMJSY guidelines at page 155,
155.
it actually starts at page 148, but the operative portion is at page 155.
Just wanted to know what is this guideline?
6.12. At
PMJS
page,
scheme and guideline.
yes. I'm specifically pleading 6.12 and
Just
6.13.
wait.
Yes.
PMJS scheme and guidelines.
Six point 12
6.12,
and 6.13.
6.13.
6.12 says that a certificate that land is available must accompany the proposal for each work. That is the DPR.
There is what page?
155.
Yes.
It will be the responsibility of the state government, oblique district panchayat, to ensure that the lands are available for taking up the proposed roadworks. A certificate that land is available must accompany the proposal for each work. Then, Lordship, page 6.13. It may be noted that roadworks are sometimes held up because at the time of the preparation of DPR, actual availability of land was not investigated, or because local panchayat was not taken into confidence about the proposed alignment and disputes subsequently arose. As a part of the PMJSY process, all states may include a simple non-formal transact work to be organized by the assistant engineer at the time of preparation of DPRs. Lordship has seen. So the transact work should be done at the time of preparation of the DPRs. Now let us see the dates, Lordship. The date of the DPR, and there are so many DPRs, but in page 304, in the signature is legible. In some, it's not very legible, so I'm pointing out 304. Page 304, Lordship will see the date down below. 304. This is a part of the DPR.
Yes.
The signature. 29/8/23. Lordship may mark the date. 29 of August, 2023. Down below on the right side. All these DPRs are the same date, but some are not very legible, so I'm pointing this out. 29/8/23. This is the date of the DPR. Then Lordship will see the technical sanction that is at page 43, technical sanction, page 43.
43.
Yes,
Go back to 43.
yes, page, next year one, page 43. Lordship will see the date.
Yes.
The date on the right side, top, 9th of January, 2024. This date may also be marked. Then Lordship will see the the land donation affidavits. All the land donation affidavits, all are exact same date. So I'm going to mention only one date. That is 19 February 2024. 19 February 2024.
Hmm.
That is in their affidavit in opposition. All the dates are the same, so I'm mentioning only one date. This is 19 of February 2024.
Hmm.
What they are supposed to do is before the preparation of the DPR, they are supposed to settle all these land issues. Then they are supposed to make the DPR. Then thereafter, it is sent for technical sanction. Here, the reverse has happened. They have settled the land issues after the DPR. This is also not permissible.
Yes, 19 February is
Land donation agreement, MOUs regarding the land. Also, they are saying the transact work.
transit work was
According to the affidavit,
same.
yes, same.
Not same date. Which difference date?
It is definitely after the DPRs.
Entire DPR is here.
Which date?
Transact work is per photo is different date. Is before. It's 2003.
Yeah.
2023.
Next step.
Yes, in one of the petition.
171.
No, in 178.
178, there is coloring one is there.
Yes.
When coloring one date is visible.
I am not finding the date here.
Different date in the photo.
The photo is not of a transact work, which they have annexed. This I say again and again, this is the survey.
I don't
This
know
is a
whether
survey.
petitioner or the technical person or
No, I have annexed a template which they normally use in this kind of projects.
Where it is? Date of transact work.
this is affidavit.
In their affidavit, they have said 1/6/2023.
16.
1/6/2023. But they have not shown the documents of the transact work. What they have shown is a survey. Although in the documents it is not visible.
I think.
I'm not finding anything here.
Oh, this is reply.
Para 6, 11, page 6 of that is 170.
No, in their affidavit, they have
I have
stated,
clearly mentioned
in the affidavit, they have stated, in the documents, it is not visible.
which package it was, transact was carried out. For each package, there is different date. Page 6 of my affidavit, para 11, subclause 1, since from 1. In case of road from 2.5 kilometer point of following Tabu Nama to Solong Tapin, package number such was carried out on 1/6/2023 and land donation memorandum understanding was on 19/2/2024. WPC 178.
Item 6.
Item 6. Even I think
Where this is? What appears to be an item?
my lord is
Page.
page 6 of my affidavit.
It says both are 171. Para.
Para 11. Sub para from 1. This is in respect of 3 package.
Both are written as 171.
Oh,
In 171, they have not annexed. Only in 178.
178, I have made about. I have replied 170, sorry.
Uh-huh.
Sorry. 170. Oh, it says-
Wait, is it here?
Yes, 171 is page 8. Yeah, affidavit in reply.
Is the reply?
This is reply.
That's my
affidavit of
reply.
petition.
I think next one. Oh.
Yeah. This is 170. Page. Yeah, 117 page. It's application. Page 8, para 13, sub-para 1.
Hmm.
That we have already mentioned. Road from Huri Tapa Biar Road to Pipa, a transit work was carried out on 26/4/2023 and land donation memorial on 19 to 20.
Yes.
And 11 others land affected person in presence of Sri Tolom Takar Jila Parishad member 5 Damin before the executive magistrate coloring whereby they had agreed to donate their personal load free of cost. And all the package are mentioned here when it was carried out. Next is 2 is 29/5/2023. Then 3 date is 26/4. Different dates are there. When it is long before. And after this, DPR was prepared and it gets sanctioned. My lord, sanctioning authority satisfied the DPR submitted by the authorities. Now, how can the petitioner say that this procedure, that procedure was not followed? After passing through several stages, the project gets sanctioned and approved and sanctioned. Without this all documentation, it is not possible to get sanctioned. Now, petitioner, they are taking the place of technical persons. They are the expert, it seems.
No, issue is not that. Issue is whether you have taken the confidence or the you had whether you have had the panchayat.
Yes, what they are
confidence with
stating.
panchayat.
The panchayat member, GPM, GPC, and Jila Parishad, they have signed.
Even the
But
GPM
if
signature is not there.
If the land belongs to them without their consent, how
That
can-
is the people who have donated land. They said is their land and they have donated. Now other set of people they come and say that
it's
it's
become
not their
it's
land.
become a disputed.
It's disputed. And even in the petitioner, my lord,
No, Lordship, I beg to
some of
differ.
the petitioner comes and say that they inform the officer that we have not filed petition. How whom to believe?
That is not on record, Lordship.
Of course,
Have you shared this? Have you
No.
yes, I have.
have you seen the reply?
I have seen the reply that anyone can say.
If all these signatures and all these things forged, how can you rely on that?
That is matter of the investigation, my lord. This has to be.
Why don't you take into confidence of all the people? What's there?
My lord, it is
They are not asking anything. They want that their names should be
Otherwise,
recognized by
I-
having a meeting. And then instead of their land, they just want some recognition
my lord. Otherwise, my instruction is that
that they have donated this land for construction of the road and
otherwise
These- they are not getting anything.
these people also
What's
no
wrong?
issue.
What's wrong in recognizing them?
Now issue is somewhere. As per my verbal instruction.
Submissions may not be made out of record.
We don't.
That is a problem we are facing.
This court should not decide on the issue which is the back of the mind.
No, in that case, my lord, this yesterday also I submit, if their land is really affected, if they are their really owner after verification, then it will be they will given due recognition. Otherwise, there is no compensation. Recognition will be given.
It is not that there
If
is no
they are-
compensation. If we demand for it,
If they are-
they should give it.
If it is their really, it is their land. Otherwise, they have to what they want recognition. They want their name in the donation list or not. That part can be always taken care of. That is there is no issue. Otherwise, the farmer is not going to pay any compensation.
That's what I'm saying. They are not asking anything. They want
My lord,
some kind of recognition.
my humble submission, department, whatever they have done that what is right, they have done it. And they have get donation from the only presence of the panchayat member, Jilla Parishad member, and they have executed before the executive magistrate.
No, Panchayat members have said that they have not signed. It is
Now-
visible in the
Now they have
annexures.
turned up and said that they have not signed.
No, it is in the documents that their signatures are not there. That
What
they-
I'm saying is that this signature donation was made on the month of February. After that, so many things turned up even happened.
No,
That may be the
that's why
issue.
those signatories and the landowners who have signed the agreement, now they are saying that they have not signed it and it's
That
a
is the
forfeit.
issue. The authority has said
So
that they have
why-
signed.
Why don't you have a meeting with these people, all the people, all the land?
Yeah, that can be,
Then proceed with thereafter. We'll accept your transact work, but the meeting with the landowners. have a
with
fr-
that
have a-
observation,
Have
this,
a fresh agreement with these people.
my lord, with this observation, then this recruitment dispose of the grievance of
Yes.
the
We'll have to admit.
petitioner
but
if they are
accept
real owner,
that
maybe.
The transact work
Yeah.
was done before that.
Lordship, I beg to differ. I'll come to that later.
Otherwise,
Yeah.
what do you want?
Lordship,
You are not entitled
It
to
is-
compensation.
it is,
It's
no,
a-
it is not that we are not entitled for compensation.
Yes.
When a land is taken by anybody, compensation should be given. Center is saying we don't have money. That's a different issue. What PMJSY guideline is saying that states should evolve some mechanism. It does not, however, mean that they can take away just like that. This system of donation and everything has been evolved only for that purpose. It is not that the land can be taken just like that without compensation. If they say like this, we may demand for compensation, so that's a different matter. But let us come to the transact work, Lordship. Just for one moment, Lordship. They have said they have conducted the transact work. In item number 16, they have
So are
annexed.
you claiming compensation?
No, just for the sake of argument, I'm saying, but
Neither is he against, not against, she is not
No,
against.
if
tender
you're
also.
claiming
no, that is
compensation.
not my prayer in the writ
if you are
petition.
Claiming compensation,
Yes,
it will be a different issue.
yes, I'm not claiming
Since
for
you are
that. At the moment, I'm not
Since
claiming
you are
for that.
relying, your pleas are based on the guidelines.
Yes.
PMJSY.
Yes,
We find that certain discrepancies are there.
yes.
So we'll direct them to
No
have
discrepancies,
a fresh consideration.
Lordship. I'm saying, Lordship.
If you are claiming compensation, the matter. would be
No,
different.
no, Lordship, I'm not. This is not the prayer and the writ petition. It's just for the sake of argument that I'm saying. Because they're saying again and again that we are not paying compensation. It's not that. If we demand, it can be paid also. But Lordship, I would like to point out the transact work, Lordship.
Hmm.
They have in item number 16, they have annexed documents saying that this is the transact work. Although it is not very visible, but it seems that the date mentioned in the photographs is the date which they have said is the date of the transact work. Lordship may for one moment take up item number 16, affidavit of opposition filed by the respondents, respondent 1 to 4. Lordship may see the date, first of all, in the paragraph 11, just for an example, I'm saying, page number 6, para 11, they have said with this certain package in 11 subclause 1, they have said the transact work was carried out on 1/6/2023. For this, they have annexed the photograph that is at page 14. It seems to be 1/6/2023. Now, I have filed affidavit in reply to this, and Lordship may take up my affidavit in reply. I'll show how transact work is done. This is a template of transact work prepared in other cases. This is Lordship page 15
Reply
to their affidavit.
178.
Yes, 178. Because
Yes.
only in 178 they've annexed these documents. So, Lordship may see this is the beginning is at page 15, but the operative portion is at page 22.
Hmm.
Page 22. Lordship may see the colored portion.
Insert the information.
Yeah, insert information. This.
Transact work.
Yes, the persons present, then number of H's is present, then the name representatives, all are there. Then thereafter, the photograph of the transact work. These are the people who have gone for the transact work. Page 23. The photograph that they have shown is of, Lordship has seen their photograph earlier, is of a single person, and he's holding some placard. In the right side is the chainage number. According to the PMGSY guideline, this is done so because at every 100 meters, there has to be a chainage number and photographs have to be taken.
My lord, this
Now,
document
Lordship-
is,
now,
from where
Lordship-
this document,
This is in the public domain. It is in the website. Then, Lordship, what they have annexed, this is the survey, not the photograph of the transact work. Then, Lordship will see,
source of document is also not there. This document.
it is in the website, it is in the public domain. Everybody knows. There is no need to do
is-
that.
This is disputed.
They are disputing their own website. Then Lordship may see the affidavit in opposition again at page 146.
Website, I don't think tender matter, once it is closed, it is not accessible.
Then Lordship,
In case-
page 40 of their affidavit in opposition. Page 40. If we see side by side, it will be better, Lordship. Page 40. Lordship has seen the earlier, which I have shown, page 22 in my affidavit in reply. This is the format they have annexed. Only the number of persons present are here. Then the names are not there. Photographs are not there. Photographs are not enclosed. What they are saying in their paragraph 11 is that by annexing these documents, this is the document of the transact work. I've seen the whole of the documents that they've annexed here. There is no date of the transact work. The date they are mentioning is that of the survey. We cannot say whether these are the dates. It has to be in the document itself, in the photographs of the transact work. This is how transact work is done. I would go so far to say, by pleading like this, they're trying to mislead this honorable court. At least the format should be in a proper manner so that they can say, okay, this is a transact work, this is not the transact work. So that is my submission regarding the transact work. Now, regarding they are saying that people that we have earlier done some.
We're sending it back for you do as per the guideline.
My lord, otherwise
And then-
also,
And issue the tender till
Yes.
such time reconsideration is will be remain.
my lord. The documents, the private party comes and they disputed the documents. And the procedure which was followed by, they are not the technical persons.
No, but these are documents prepared
And,
by the department.
disputed
In
pa-
that case, department, they may be allowed, records may be called for how it is done in other cases.
Otherwise also, now it's
They will
hotly
not be able
disputed
to,
matter.
they will
It
not
cannot
be able to bring such kind
adjudicated.
of documents. I can bet
Ma-
that this is the document
My
they
lord,
should be
the
bringing.
petitioner is not against the tender process. They only want to recognition. My lord have rightly observed that.
We may be agree with
Oh,
the alignment
This
also.
matter may be disposed with direction to have a meeting with the petitioners and have what is their grievances. And they can be find amicable solution. Instead of sending back and doing all this process, my lord have rightly observed that can be, with that observation, this writ petition can be disposed of. And I am sure that if this case is pending for a week, they will withdraw.
Hmm?
Then let it be pending for a week. He is asking the court to do from Z to A instead of A to Z. And there's raising the question of
Otherwise-
disputed
Otherwise,
facts.
normally what practice they are doing, of course, they may be not accordingly exactly what guideline is. But normally they used to do when where there is no issue, there is no issue. It goes on.
Submissions may not be made out of
Ah.
record, may not be made out of record. This honorable court may not take into account.
And according to the officer, this was transact what they have get donation and they have done and it was sent to the
If we go
authority.
strictly, the officer
And they
may
get
go,
sanction on the
may
basis
be
of this
liable for
document.
forgery. We can do that as well.
And if the petitioner found that their signature is forged, they have every liberty lodge a complaint. Police, this is another matter again. On that, this developmental activity cannot be stopped.
My lord, where is your representation?
My representation is of no value now because everything has been
No,
done.
we'll direct them to consider your representation.
There is no point, Lordship, because even if they consider my representation, suppose they say yes to the representation, in that case, there may be a question of alignment. In such a case, will they be able to redraw the DPR? Will they be able to go back to the technical sanction? Or that they'll have to redo everything? It is of no avail.
If they- Every inch of land is not individual's land. It's a community land. In some portion, someone's land may be there.
Find out that and then settle it.
And they have done it. They say the blessed land free, they have already give the region also.
I think this must be the first case in which all these things are done after the DPR. This is not at all permissible. This will set a precedent. They have to redo the tender. The tender comes only after DPR and the technical sanction. And the DPR comes after the land settlements.
Now, my lord, may I have the audience from the court as an interview?
So far as the interveners are concerned, Lordship, since
Madam,
they are, since they,
madam, you have
let me
taken
submit.
You have
let-
taken substantial time, please.
No,
allow me
no,
to submit.
no, then let-
You
let-
cannot
let me-
stop me.
No, let me
Yes,
submit
no.
first. I have the right to submit first. So far as the interveners
You
are
have
concerned,
enough- you have
since
made
they are
enough submission.
contractors, if they reissue the tender, will they not get a chance? Who is stopping them from participating in a tender?
Hold on. Make,
Where is the tender?
Tender is, Lordship, page 49. This is the tender which was recalled. The tender which is now operating is at page 52, 13/3/2024. Page 52, the down portion.
Monte Carlo.
In both the writ petition.
Yes, same.
We are disposing now.
No, my lord,
We are sending it back. See, the agreement was made on 9/2024
19.
before the approval. of the authority. We may agree with the so far as the transit work is concerned, but then not agreement because the guideline says that you'll have to have a discussion with these landowners because they are not getting any benefit, I mean, compensation. That has not been properly done.
Now, my lord, sending back
There
maybe.
may be a counterclaim. That's the reason why not go into the whether they are right or you are right. Though they have at least serious allegation of forgery of the case, I mean documents and all, and they are saying that these are all disputed. You
That-
reconsider it.
Yeah. Then in that case,
Transact work will agree, whatever may be. What is transact work actually? What is to be done?
In transit
Practically.
work,
it
they are
is
supposed to,
otherwise is survey only.
Work.
they are
It is
supposed to,
survey only.
no, survey is different. Survey they do first. Transit work, they take the people, the panchayat leaders and whoever is some persons who are present. They see the alignment of the road, whose lane is there, which way the road will pass, that sort of thing, so that they can assess as to what persons may be, who will be willing to donate, who will not be willing to donate, that sort of thing. That is why it's very important.
Since you are not opposed the construction of road, your
I may be,
your-
some of
will-
us
will
may,
allow you to file representation, press representation, whatever grievances you have, that will be considered in accordance with the guidelines.
if in accordance with the guidelines, the tender has to go. Tender has to go. They have to reissue the tender.
We'll direct them to consider it within 1 month. Till such time, you wait for them.
No, no, that is the reason why I want to make a submission as an
Yes.
intervener only in respect of
See-
the
see-
tender. Because the order of this court itself has given me the right to make a submission.
Yes.
So therefore, I cannot be stopped.
No, I'm not stopping. Who is stopping you? It's just,
There
I,
cannot
I,
be bully from any side.
this court is hearing the petitioner first, and then hearing him, then I'll come back to you.
That's why,
They have not completed, just I'm interested
No, no.
with them.
I think substantial, because
It's okay.
the
It's okay.
government council is making submission.
No,
they
you are not-
interrupted.
nobody-
Again, there is an
No,
interruption.
no, your turn is coming. Don't worry.
No, that is my.
So that's
concern.
all. Yes, that's all. What do you want? What Supreme Court decision?
My lord,
NG project.
and the project and there is other also.
Those
Even if there is some irregularities, it should be
Aberrations. of- Yes.
aberrations in the,
other, with that
Sir,
observation,
all of us
yeah,
conscious. It's okay.
this is a very national important project.
Yes. We're not stopping you. It's
Yeah.
for a
what,
few days only. You
What is
consider their
the-
right also. After all, they are the landowners.
what is the harm in reissuing the
If you-
tender?
If you find that they are not the landowners and then you reject it, whatever is there.
Yeah, we'll verify that
Yes,
part.
verify. Consider it. We'll ask them to file a press report. Yes,
But the first question is.
let me have a privilege to hear.
Malad, the first question is, the read petition has been filed without making us the party.
Yeah.
Therefore, on joinder and misjoinder of the necessary parties, I'm raising the question of material because it is nothing but a question of separation of material. When a tender was floated, process is on. When third party interest is there, how you can impute it? At least by impleading us, the petitioner ought to have put us on notice.
Now you have been implemented.
We have filed the impleadment petition that was also objected and then we are converted to an intervener
Okay.
to an extent that we should be able to make submission only to the tender aspects. Now, my lord, first thing, these read petition must go for separation of the material fact 1. Number 2, for not making us the necessary parties. On this 2 count, this must go at the first place. Secondly, my lord, that page 155, page 155, which my learned friends refer to,
Guideline.
paragraph 6.12
Guideline.
of the guide.
Hmm.
Now, the guideline itself provides so,
Hmm.
even if, well, kindly have this page 155 of the petition
Yes.
itself. It will be the responsibility of the state government, the stroke district panchayat, to ensure that lands are available for taking up the proposed road works. A certificate that land is available must accompany the proposal for each road. I am pausing for a moment.
Yes.
That is the stage of formulation of a DPR. Now, that particular land availability certificate has been given by the district authority. No whisper was made when this particular certificate was issued. Belatedly,
Who has issued the certificate?
Nobody, because there is no certificate.
No.
no, that it is there.
Non-duplicacy certificate.
Non-duplication certificate, no, that is not. In their affidavit itself, government affidavit. In the government
See,
affidavit.
method is very simple.
No, I'm coming.
What
I
they are
understand.
saying is, they are not opposing the construction. What they are saying is, before you start all this thing, as per the guidelines, you have not done it. So do it. That's
Then
all.
I formulate this way, my lord.
Yes.
Let tender process be continued. Because there is a dispute between the government and the petitioners. Otherwise, my lord will see that Jagdish Mandal judgment, my lord. There are 22 is very clear. Ronak, my lord.
But at the same-
Ronak and that,
what is your right? You don't have a fundamental right to do business with the government.
I understand, my lord, I don't have. But
You
I have
participate-
been prejudiced by filing this writ petition without putting me on notice, my lord.
You have been you have implemented now.
No, therefore, my lord, let the tender process continue. If at all there is any, because neither this court
See,
nor we
problem
are
is
experts.
once we allow them, if the tender, if we allow the tender to proceed, tomorrow if it is established that it is their land which has not been done, it would be a mere formality to direct to reconsider.
That is.
You wait for some time, you'll get it. He's not, they are not against you. They just simply want that since they are the landowners. I'm not saying that this court will never say that they are the landowners. We'll direct them to file a representation and the authorities will
Correct,
consider
correct.
it
That-
in terms of the guideline. That's all.
In the meantime, my lord, that's within 1 month, the tender process shall not be continued. That much, without interfering with the tender or tender thing.
Till the consideration of the
Representation,
in terms of the thing. then
correct,
we will
correct.
decide.
That
That's
is,
all. Is not it?
Lordship,
NIT should not be questioned, that's all.
just a short reply, Lordship. The fact that this honorable court
Yes.
has, in the IA filed by them,
Yes.
that is IA 74 of 2024,
Yes.
has rejected their prayer from making them respondents and instead only made them interveners. This shows that they are not a necessary party. So there is full stop. Another thing is, Lordship, since they've issued the tender without doing all the necessary formalities, it amounts to a null tender, Lordship. That DPR and everything has been, like I said earlier, I'm not going to repeat myself. So if the tender is reissued, what is the harm in doing that? What right would be of theirs will be violated? The department can do that so that everything is in proper manner. These kind of projects are in all districts in border areas. This is must be a peculiar case in which forgery has been resorted to. So therefore, this is a fit case.
You have a liberty to approach. While filing,
But since Lordship has found that the documents that they have annexed is prima facie forgery,
Oh,
in that case,
Cannot-
it-
no, we cannot say, we just give you
Yes.
liberty.
I have given the official documents also, their documents, Lordship. I'm pointing out their documents. In their documents, they have said the GPC has signed. In the documents, in more particular in page 103, 124, and 131, 136, sorry, Lordship will see, their signatures are not there, not even forgery, signatures are not there. Those are the GPCs. So Lordship, the tender may be cancelled
My lord,
and
when
it may be reissued
petitioner
as per their
scrivens are
convenience.
directed to address, again going back to tender is.
No,
No, no.
there,
At MS and learned counsel for the petitioner, both the writ petitioner and Mr. No, Mr. Jeetar, learned standing counsel for Rural Works Department for state response and Mr. Tititar for intervener.
Only in the item,
Intervener. In item 171, in writ petition 171 of
only I
2024.
And share with order dated 28/5/2024. One last line was there. The intervener are permitted to file their affidavit with limited time insofar as challenge to the tender process. There cannot be full stop.
So you have filed.
No, I have not filed it because, see, basically it is the government who has to justify their actions. I can only make a prayer without passing the NI. Let
As
the
the,
file president.
Sure, thank you. As the issue involved in this two writ petitions are similar. Come on. The writ petitions are taken up together for disposal by this common order. Next paragraph. The petitioners in both the writ petition claims to be the landowner.
Allegedly a landowner.
Claims to be the landowner of which place? It's entire district,
Lordship,
Different place.
different blocks of the district.
a different block
I have mentioned in,
in the different blocks within the district of Kurungkumai
Kurungkume.
have have put to challenge the impugn tender. What is this? It is NIT.
NIT,
No, it is e-procurement press notice. Impugn tender, comma, e-procurement press notice dated 13/03/2024. Issued by the Executive Engineer, public DPIU, comma, Line Yangtze Division, ARRDA, comma, RWD, Kurungkumai. Whereby, no, not whereby, inviting item rate bids in electronic tendering system for construction of road under PMJSUI, including their maintenance for 5 years from the eligible contractors registered in appropriate class in the district of Kurungkumai for 26 number of packages, comma, on the ground that the impugn tender has been issued in violation of the PMJSUI scheme and guidelines. MS and Danget learned counsel for the petitioner. On taking, referring to the PMJSUI scheme and guidelines. Particularly, clause 6.12 and 6.13 submits that a certificate. It is the responsibility of the state government of the district panchayat to ensure that the lands are available for taking up the project road works. A certificate that land is available must accompany the proposal for each road work. So the PMGSY does not provide funds for land acquisition. It doesn't mean that the acquisition cannot be done by the state government at its own cost. The state government is also given liberty to lay down guidelines for voluntary donation, exchange or other mechanism to ensure availability of the land. So many things to be done. It says if the state government, even if it's under PMGSY, may not provide compensation, the state can acquire the land on its own. Obviously, the state will not do that.
The repair, they said that, like, mention,
There's no bar. Only PMGSY scheme doesn't provide compensation, but the state can acquire it.
but otherwise.
In any case, under the law,
It is mentioned. Although there is no compensation, but in case there is effect,
Please, Steph.
in the,
See,
some
further
supply
check-
work or some
where is-
contractual work used to be, that is there.
submits that. It clause 6.3, 13, among others, it provides that as a part of PMGSY process, it may include a simple, non-formal transit work to be organized by the assistant engineer at the time of preparation of DPR. The panchayat will say just panchayat members and the J means a junior engineer.
yes.
Junior engineer would participate. And in case of forest land, the officials of forest department should also be involved. But please stop. She submits that such a requirements under the PMG scheme and guidelines have not been complied with. And without following the said guidelines, the This is the project of what village,
This is road construction under Vibrant Village.
such road construction, that scheme or the project cannot be implemented under the vibrant village,
Vibrant Village.
vibrant
Vibrant Village Program, VVP
Some road is 5 kilometer, 8
vi-
kilometer.
vibrant village
programs.
programs. Project or program?
I think it's program. Let me see again, sorry.
Because the
Vibrant Village Program.
vibrant village. This NIT does not indicate that the program is not it.
No, it does not indicate.
90. In the website, it will detail will be
MS
given.
and target learning concept. Come on. Referring to the documents annexed in the writ petition as well as affidavit in opposition filed on behalf of the state response from some extent. There are serious discrepancies in the said documents as the land documents, land agreement has been executed on 09/01/2024. Whereas the DPO was prepared on 29/08/2023. And the approval was accorded. Where is that approval by the state?
Technical sanction is at page 43. Page 43. That is 9th of January 2024.
Approved by the state, approved by the authority on 09/01/2024. He submits that as per the guidelines, the DPR has to be accompanied by transactor, followed by, preceded by
Land availability certificate,
land availability certificate,
transact work,
transact work, and
and other land documents.
and other land documents. See further, I see, while referring to the land donation agreement, she submits that either there is no signature of the persons who has alleged to have donated the land, or the
Many signatures have been
many
forged.
signatures have been forged. Therefore, she submits that such a documents, there's such a forged documents, and not only in not following the guidelines, but on the documents which have been forged cannot be relied for execution of the project, which is beneficial to the common people in the area, as well as depriving the rightful, depriving the land owners in the district.
Also, Lordship, that the documents are anterior after the DPR and the technical section. Lordship, that part has not been
I have
mentioned.
not used the word anterior, but then I have said.
Lordship.
Anyway, she
19
further submits that the documents
Where,
relied by the annexed and relied by the state respondents.
where on the date of those documents were 19/2/2024, 19/2/2024, which is anterior to the DPR.
19 to 2024.
Yes,
And
which is anterior to the DPR and the technical sanction, which could not have been done as per the guidelines. Because
which are anterior to the DPR and section.
technical sanction,
sanctions.
yes. These are to be done first, then DPR comes.
As
Be-
these documents are to be prepared before the DPR.
Yes.
the technical sanctions are accorded.
And accompanied to be annexed with the DPR.
Next pair. On the other hand, Mr. G. Tarak, learned standing counsel for RWD, while referring to the documents annexed to the affidavit in opposition, submits that as per the scheme and the guidelines of PMGSUR, transit work have been conducted, it will say conducted,
Yeah.
conducted on
Various that depend on.
various dates and is before the DPR
Before
was
this year.
prepared. The DPR was prepared and submitted, and the technical sanction was accorded. He has also relied on the land donation agreement signed by different persons to show that the land has been donated by the owner of, lands have been donated by the owner in the different locations within the district of Kurun. Then Mr. Titi Tara. Then what else? You are saying that all these are done before that.
Yes, and this project is of national importance.
Therefore, he submits that since the required action has been taken in terms of PMJSUI scheme and guidelines, and since the project is of national importance, why national importance?
This is international borders, Chinese border.
National importance under the under the program of vibrant village.
That point, international geopolitical reasons, this project has been initiated.
That we'll see. The tender should be allowed, the process of impute tender should be allowed to continue. And the project be implemented for interest of the public. And you are saying that it's not maintainable.
It's not a mental.
He further submits
Isn't
that
it-
at best the issue, no, not at best. He further submits that the writ petition is not maintainable as the issue involved of whether the land
Disputed.
belongs to the petitioners or belongs to the persons who have donated by signing an agreement is purely a disputed question of facts which this court may not embark on to decide such disputed question of facts. Then, what
Moreover,
are
that-
you relying some judgment?
Yes. That is to the NG project, and there is other one. Same,
He has Mr. G. Tarak has relied on the judgment in the case of, where is the NG? This
NG is here, no. This is other one, hotly or disputed fact should not be interpreted.
huh?
This
This
is
one. Relied on the
para 26.
judgment in the case of Subhas Jain versus Rajeshwar Shivam.
Para 26. Then NJ project is
To project that in support of the submission and to project that while exercising jurisdiction while exercising its extraordinary jurisdiction under Article 226 of the Constitution of India, the High Court does not adjudicate hotly disputed question of facts. It is not for the High Court to make a comparative assessment of conflicting technical reports and decide which one is acceptable. Then
in case of
See,
NJ
further-
project, that is para,
you just said he relied on the following judgment on its own.
para 14.
In the case of
NG, this is a National Highway Speed Rail Corporation.
NG
Limit-
project,
in the NG project,
NG project versus,
That Monte Carlo below.
of Vinod Kumar,
no, NG project versus, there is also some J.
Vinod Kumar Jain.
Vinod Kumar Jain, reported in
Para-
2022.
26, 22.
2006.
22, volume 6.
Page.
Page-
SCC
Page 127.
127,
Then para 14 is,
para 14. What does it say? Normally, it should not interfere.
yeah, even I will just read out the relevant person. Even in case where the High Court is of the prima facie opinion, the decision is such perverse and arbitrary or suffer from maleficence and or favorism, while entering such writ petition or pass any appropriate indictment, the High Court may put to writ petitioner notice that in case petitioner loses and there is delay in execution of project due to such proceeding initiated by him, they may be saddled with damages caused or delay in execution such projects.
To project that in the tender matter, normally the High Court should not interfere as it affects the public interest in the implementation of the public project. I think not para 11, something more, some para will be there.
And public, there are so many.
There are obviously,
yeah,
but then you
public
have
interest.
realized the wrong paragraph.
Public interest is always there.
Next para, Mr.
At the cost of
Sir,
few interested party,
council-
public interest cannot be override.
For the intervener. Submits that the writ petition is not maintainable due to non-gender or misgender of the parties. Lister, he submits that non-gender of and misgender of party amounts to separation of material facts. Is it so?
Correct? Because
Non-gender and misgender is amounts to separation of material fact.
that is material fact. For the reasons NIT was plotted, we participated in the tender. Deliberately, we have not been made.
he submits that since the prospective, not prospective, since the bidders who have participated in, have you participated?
We participated in all
Since the bidders who have submitted their bid pursuant to the impugned tender 13/3/2014, 24 have not been added, implemented as party respondents in this proceeding, comma, such non-implement amounts to suppression of material facts. Therefore, he submits that a writ petition may be dismissed on the ground of
non-joiner of the part, necessary part,
non-joiner of necessary
and
parties
separation of the
and
material facts.
separation of material facts. Consideration is extended to the learned counsel for the parties, the submission of learned counsel for the parties, and payments the materials. Next one. The next paragraph. Government of India, comma, Ministry of Home Affairs, comma, Department of Border Management has accorded approval of projects, project proposals under Vibrant Village programs for the state of Arunachal Pradesh, which includes the locations accorded, huh? What is that last one? Not inclusive, before that. I had recorded approval and sanctioned the proposals submitted by the state of Arunachal Pradesh for an amount of rupees 220 no, 2205.19 crores for construction of road under PMJSY. It also the approval, public sanction has been accorded subject to the fulfillment of following conditions. Page 43, huh? You just put it. 1, 2, 3, 4, 5. Yeah? In the present case, on perusal of the records, the requirement under the PMJSY scheme and guidelines have not been, appears to have not been followed properly. Please stop. It is brought on, it is revealed from the record that the DPR was prepared on 29/08/2023 and the land donation agreement then have been executed on 09/01/2024. The
0901 is technical sanction, Lordship. Agreements are 19/2/24.
okay, 19
19/2/24. 19 February 24.
yes. Agreement, land agreements.
Yes.
Then donation.
Technical
Land
sanction,
donation agreements have been
land agreement and MOUs.
MOUs have been entered on 19/02/2020. And the approval was accorded, approval and the sanction was accorded on 09/01/2024. Please stop. The petitioners also, the land council, but the petitioner also brought on record the discrepancies of the documents relied on by the state response. Listen. Next paragraph. Though the landed council, though the state response have attempted to show that the transit work as well as the other requirements like donations, the land donation agreements have been complied with by following the PMJ scheme and the guidelines. On perusal of the state documents, it doesn't, it reveals a contrary, it reveals contrary it reveals a contrary, it reveals the contrary situation which with the requirements provided under the PMJ scheme and guidelines. Next bit. It is noticed that one amongst all the conditions of sanctioning the project proposals under vibrant villages program is that the latest SOP related to PMJ issued by MORD shall be followed while implementing the road project, including any amendments in the SOP issued from time to time. Clause 6.2, 6.12, of the PMJSY scheme and guidelines provides as under page 155. Next page. And clause 6.13 provides as under. Just quote this, 6.1. Next page. On the bare reading of the above two clauses, which regulates the present project under the Vibrant Village program. Goes to show that the certificate that land is available must accompany the proposal for each road work. The state may lay down guidelines for voluntary donation, exchange, or other mechanism to ensure availability of land. It also provides for among others, transit work to be organized by the assistant engineer at the time of preparation of DPS. Next one. In the present case, though the state council has attempted to show that the project work were conducted much before the DPR was finally prepared. It doesn't reveal exactly on which date the transit work was carried out, conducted, and whether it was as per the requirement of the scheme or not is not clear. Mr.
I have mentioned in my affidavit, various dates. Date I have mentioned in that.
No, you have tried to, that's why it's my view.
Okay.
All right. Admittedly, the project was approved, public sanction on 09/01/2024 based on the DPR prepared by the department and submitted by the government of Arunachal Pradesh. The land donation agreement have been made on 19/02/2024. The scheme and the guidelines requires that the transit work, then land donations and other requirements has to be accompanied, it has to be preceded for preparation of DPR. Mr. However, in the instant case, except to claim that the transact work was conducted prior to the DPR, no other requirements as provided in the guidelines is shown to have been followed. Next one. Having regard to the submission on the maintainability, either on the ground of non-gender or misgender parties in the writ petition, as well as disputed and on disputed question of facts that this court would not normally enter into such issues. And also that non-gender of necessary parties to the necessary parties as that of the interveners who have participated pursuant to the impugned NIT, not been added as party respondents, which according to the responsible petitioner is amounts to separation on material facts, are considered to be rejected in as much as though the claims and counterclaims are projected to be a disputed question of facts. The issue involved in this present proceedings is as to whether the state authorities has followed the guidelines of scheme and guidelines of PMJSY before preparation and the sanction of the project under the Vibrant Village program. As noted above, this court finds that the scheme, the requirements under the scheme and guidelines of PMJS have not been followed in its letter and spirit, whereby which is a condition precedent for a project. There is no question of entering into the disputed question of facts. The disputes sought to have been raised. No, please stop. This court is not entering into the alleged disputed question of facts which sought to have been raised by the parties. At the same time, it is true that whether the petitioners are the owners of the land or the persons who have been donated a land for the project in the present, that such issue would not be a subject to be, it would not be an issue to be deliberated under the jurisdiction. The allegation of forgery is also equally cannot be run into the present proceedings, as the petitioners have the remedy under the law if there is any forgery committed by any persons to any documents listed with regard to the documents with any documents listed. Considering that having regard to the non-gender of necessary party and the sufficient material facts of this court is also viewed that since the issue raised by the petitioners does not would not cause any prejudice to the intervener who claims to have participated in the tender process, they seems to be not a necessary party. Mr. In the facts of the case, the petitioner would not know who are the bidders unless the tender is completed, or for that matter, unless the petitioners they themselves are the bidders to participate. In the present case, the claim of the petitioner is that the issue, the grievance raised by the petitioner is not able, is only to the extent that before the issuance of the tender, the process for preparation of DPR as well as the sanction of the project, the condition precedents as required in the PMJ scheme and guidelines have not been followed.
That's correct.
Therefore, neither is any non-general party or misgeneral party or a separation of material facts. Therefore, the permanent submissions raising the maintainability on the ground of non-joiner and misjoiner of parties as well as separation of material facts and also the disputed question of facts are rejected. Coming back to the, not coming back. Having considered that the state respondents have failed to follow the required conditions under the PMJ scheme and guidelines for implementation of the project under village vibrant programs, vibrant village program. I'm of the considered view that the responsible authorities are deserved to be directed to consider the grievance raised by the petitioner and to follow the requirements of the guidelines, scheme and guidelines of the PMJ. Consequently, in view of the above, I'm of the considered that it would serve the interest of, it will, I'm of the considered view that the present petition can be disposed of with a direction to the petitioner to file a fresh representation or raising the representation, placing the grievances before them. Which authority?
Secretary, then will direct division officers.
Who would be the appropriate authority? Whom you have filed a representation earlier?
DC, because he's supposed to give the land availability certificate. That is why.
We'll say,
But whether or not the tender can proceed in such a manner, that representation would be to a different authority, not to the DC, because
so you
DC.
file a fresh representation.
But since your lordship has found that they have not done as per the scheme, what is the harm in?
We'll have to balance. We'll have to
Because
balance.
what will happen is we'll file a representation, they'll reject, we'll come back again. It is only multiplicity of petitions.
But then this court is of the view that will allow you to file representation.
Because if
within 1
they
month.
cancel the tender and reissue it in a proper manner, it will be a benefit of everyone, including the interveners.
No, I'll make it, make it clear.
It shall be,
It's okay.
secretary.
Do file a representation before the
Secretary authority.
appropriate authority. Namely, Secretary RWD. Can
Secretary.
you do it?
Secretary authority.
Secretary RWD. Right?
Yes.
Secretary RWD. Within a period of 15 days from today, list of in the event of
Lordship, 1 month,
petitioners.
1 month, because there are lots of petitioners, Lordship. They have to come from there. Taking signatures are difficult.
So 1 month will be too long
Too long.
because we'll be staying the tender.
Yes.
We'll suspending it till your
Representative.
disposal. Yes, 20 days from today.
Lordship, 1 month, because there are so many petitioners. Difficult for to gather even.
Nowadays,
Yes, yes.
get the, what we call it?
It takes 5 hours to reach Colorado.
No, but these are villagers. No, these people are not staying in the towns. 1 month, Lordship.
1 month is too long. No, to file a representation
Yes, they'll have to sign the representations.
within 15 days from today.
20 days, Lordship, then
Not
at
all
least.
the petitioner is necessary to sign also.
Representative capacity, you can do it also.
They'll have to give a representative authorization
Within
letter.
a period of 15 days from today, in the event of, no, Mr. On receipt of the representation, the secretary. That's why I'm asking, is it if we direct the secretary, if it's not, tomorrow if it turns out to be not an appropriate authority,
No, yeah, if direction is given to secretary, then he will take the help of he will direct again to the
receipt of the
authority concerned at district.
representation, the secretary RWD shall consider and dispose of the representation, taking into consideration of the PMJ scheme. No, in accordance with the requirements provided under PMJ scheme and guidelines. And in terms of the observation made in the writ petition, in this present proceedings. Observation made by this court in this present proceedings. Question. Till the exercise directed to be carried out shall be completed
Within 1 month.
not later than a month after the receipt of the representation. Yes. In the meantime, the impute tender NIT dated
13/3/24.
3/2024 shall not be proceeded further.
Lordship, at the back of my mind, the problem with the time given is that suppose we file representation, suppose it is rejected, then there is a court vacation, we cannot come again. There is also a problem. Lordship may,
No, 15 days.
within 15 days, there will be a court vacation.
Huh?
That is why,
Then-
Lordship.
Then 1 month.
At least 1 month time may be given for that.
Come on 16 July.
No, it is, if he wants to, he can dispose of within 1 day also. I cannot say that. No, that is why.
Not possible.
No, that's why it cannot be just like that. It should be taking into account the requirements of the PMJSY guidelines as well as the observation of this. court.
Yes, I know, Lordship, but if he rejects my
They
representation,
cannot-
if there's a court vacation, that may be a problem,
They
Lordship.
cannot decide it in a day. They may decide it, but then they may ask for the to follow the requirement.
You
In
know,
that
Natal,
case, it will
anything
take
can
another
happen.
2 months.
Secretary will call all the officers.
Well, we cannot prejudge.
I'm just trying to protect my clients. Oblige.
Oblige.
ये आइए है तो ना आइए में पास करो इसको अगर उसमें मेन में इंडिया का पासवर्ड से This is. Then objection, no. Yep. Okay. Yep. So go.
The instruction is that lawsuit, they have not yet filled up lawsuit, since it's a OSJ lawsuit.
They cannot.
And here lawsuit, since Public Service Commission is not working lawsuit. So still we want that person, still that recruitment is done lawsuit by the
Why not working?
lawsuit.
Why not working? Public Service Commission?
No, because requisition was sent long time back lawsuit.
Yes.
So because of the Dipang lawsuit, that point of time lawsuit, now though is, they have been appointed lawsuit. But selection process not yet is initiated by them till today lawsuit. So therefore, department is running lawsuit in sort of manpower. That's the only lawsuit limited, and it was done lawsuit with approval from the government lawsuit. This contractual lawsuit. On pile noting, it's till this selection is done lawsuit. For limited purpose.
No, that authority I'm challenging, well.
Yes.
Under what authority, my lord, this
No,
executive,
they are saying that they need manpower. And they have sent the requisition already. Therefore, for a limited purpose.
But that should be within the, when there is a recruitment rule in place, my lord, within that recruitment rule. The executive cannot beyond recruitment rule, my lord. There is no such provision, my lord. Even if suppose for the time being, rule can be relaxed, my lord. That should be the recruitment rule provide with the advice of the board, my lord. Here in this case, my lord, on the record, my lord, the board, my lord, they have not taken a consent of board. The executive itself, my lord, but they have not taken the consent of the board, my lord. Board in the sense, service commission, board, like service commission and
Commission.
and the board, my lord, in terms of for C grade
As
is
per the rules.
Rule
It's required.
Yes, rule required, my lord. In
Where
case
it
of
is?
some relaxation, my lord.
Where it is? As per the recruitment rule.
Rule, my lord.
What board, what is required? What is required?
My lord will kindly
As
turn
per
to my
rule.
lord. This is my lord, page number 50, my lord. Is Arunachal Pradesh Staff Selection Board Act 2018, my lord.
50.
50, page number 50, annex number
Where
6.
What does it say?
This is the, by this act, my lord, the recruitment authority of the department, my lord, to make a recruitment, my lord, has been denounced with, my lord.
No, you are right. They cannot fill up like this.
My lord,
But then what they are saying is they have already sent the requisition
my lord,
for recruitment.
my lord.
But then they are sort of manpower.
Madam.
So for a time being till it is recruited,
Mhm.
they want to engage on contractual basis.
They,
That may not, it may not harm it.
my humble, even if my lord, there is a some
Because, you know, practically recruitment process takes time.
yes, my lord, even some for
Suppose
that,
if they are appointed, we'll make it clear that if appointed only for the period of 6 months.
no, my lord, for that also, my lord, rule provide that, my lord, the advice, my lord, the auto advice should be need to be taken from the board, my lord.
Where
That
it is.
that at page 59, my lord. Suppose assuming, my lord, this for the time that can be relaxed, my lord. There is
59.
59, my lord.
The junior engineer will go to Public Service Commission.
Commission, my lord.
The other, only one post will go here, SSB, right?
My lord.
What is that?
Even assuming, my lord, power to react, my lord. The government opinion,
Estimator.
it necessary to expedite do so. It may
Surveyor
provide-
will also go there.
My lord.
Surveyor,
Surveyor,
Public Service Commission.
no, my lord. So it is board, my lord.
Huh?
Board, my lord. On a staff selection board, my lord.
Surveyor and junior engineer. Estimate,
APS,
junior estimator,
my lord.
okay. Where it says,
When a government is of the opinion that it is necessary or expected to do so, it may by order or provision to be recorded in writing and in consultation with the board, my lord.
then it says how to relax.
Yes, my lord, which consultation with the
They
board,
are
my
not-
lord.
It's not a question of relaxation. They want to fill up it for certain period.
Certain period. Then also, my lord, assuming my lord, that can be done. Then
We'll-
also,
we'll
my
make
lord,
it clear. We'll
No, no.
make it clear.
then also, my lord, the other office memorandum saying the recruitment, my lord, should be in the written, my lord, written in the by other.
Yeah.
Now they are doing in working interview, my lord. We are against that, my lord. They are calling for only working interview, my lord. Now, when my lord repeatedly, my lord, there should be sensitivity in the recruitment process, my lord. Transparency and fairness, my lord, is the necessary, my lord. Now, when the mode of interview, my lord, selection is only working interview, my lord, there is a very scope, my lord, for foul play, my lord. That's why, my lord, though we will eligible, my lord, with participation, we will against that, my lord. Even assuming, my lord, they are recruiting of for exchange of service, my lord, that should be, my lord, not in only by the mode should be not in only by the working interview, my lord. That the legal point I'm making in this case, my lord. If my lord turn to kind of page number 66, my lord, 66, my lord. Annex number 9, my lord.
What is this?
9, my lord. This say, my lord, order recruitment upon a group C in multitasking, which are now group C post again direct importer under government supporters, and it attest office shall be conduct or retain examination the following moment. So we are saying, my lord, if they suppose there is some urgency, my lord, then it manpower, my lord, then they should follow this, my lord. There should be transparency, my lord. This is the public post, my lord. By only mean of working interview, my lord, they are trying to fill up the JE, my lord, post of JE, my lord.
We can choose.
Vacancies, my lord. Possible, any possibility, my lord.
So if they want to fill up, it should be preceded by
Written, my
written
lord.
examination, even it's for contractual.
Oh.
You have no objection as such. If it's for 6 months.
If written, my lord, we have no objection. If suppose if they now about the exchange of service, my lord, the approval, my lord, was for 6 months, my lord. The advertisement is in 2021, my lord. Now it is almost 6 years, my lord, 4 or 3 years, my lord. Now department is running smoothly, my lord. They are performing well, my lord. Itself so that, my lord, there is no exigency, my lord, for my lord.
Why you want to just 2 years? Why there is no recruitment process?
APSC was debunked for last 2.
It's okay, we understand about junior. What about B and C?
APSC also knows if
Surveyors, junior estimator.
still the matter is pending for the APSC.
This one
Yes.
for last 2 years.
Yes.
Why? There's so many recruitment.
Even reminder was saying.
Recruitments have been conducted.
Other by humble submission, my lord, this can be as this will proceed, my lord. My humble submission, this can be hard on land, my lord, and can be tested on legality, my lord.
Huh?
This can be tested on merit, my case, my lord, can be tested on merit, my lord.
I told I will dispose of the above. Will allow your repetition.
Other aspect also is there, my lord. In this case, my lord, I have to indicate so many provision in this act, my lord. That time, my lord.
No, why not? We'll resume it to 1, 2. We'll see. What is the next one? We'll resume, it will take it up to 2.
Eight, my lord.
What happened? Is there any interim order?
Interim order, my lord. Interim order is staying in my favor, my lord.
But I am challenging, my lord, the eviction order under section 6, my lord. Now, my lord, no, my lord, I will be having a limited chance, my lord, in this case, my lord. Yes, my lord, this is the ground I am raising in this case, my lord. The statutory authority who passed the eviction order, my lord, has made brought to the statutory provision, my lord. The order, my lord, by which eviction order passed, my lord, was not passed independently, my lord. Suppose if I am on unauthorized call, my lord, in eviction order passed, my lord.
Maybe from any sources,
So, sir, my lord.
any source, whether somebody comes and makes a complaint, doesn't make a difference.
My lord.
Facts remain that you are unauthorized occupant. Unauthorized occupant.
I would say, my lord, I'm implied in authorization, my lord. I'm under implied authorization, my lord, in this case, my lord. Where, my lord, if we go into the lane allotment application, my lord, itself say, my lord, before make the my allotment, my lord, I need to possession of the some lane, my lord. Since when, man? That is a clear point. I need to have some possession, my lord, of the land. Thereafter only I need to apply for the allotment, my lord. Now, in this case, my lord, my argument will be, my lord, if the statutory authority, my lord, exercise the statutory authority in bait, my lord, in mailing, my lord, High Court, my lord, need interpreted, my lord. Now, on the record, my lord, I also, my lord, the eviction order, my lord, passed by the statutory authority, my lord, was in bait, my lord. Not independent, my lord.
No, that's what
Ultimately,
I'm
my
saying.
lord,
Let us assume that it is the basis of the information was from anywhere, any source.
no, not only information. My lord, says two things in this case, my lord. One, my lord, as much as my lord.
No, facts remain that are you occupying the land?
Yes, my lord. Yes, my lord. Truly.
Have you got the allotment?
No, my lord.
Is it government land?
Yes, my lord. Government.
Matter ends there.
Pardon, my lord.
Is matter ends there?
No, my lord. They do have, my lord. We need to look into the other aspect.
No.
In this case, my lord.
It's an eviction petition. Eviction order has been passed.
My lord.
Against you.
My lord.
Who is in unauthorized occupants of the government? What's wrong?
No, my lord. If my lord.
Who made a complaint? Who has not made a complaint? It's immaterial.
That way, my lord. If that authority, my lord.
Can you say that even if you are illegal or unauthorized occupant, can this provision this provision would not apply?
No, no, man. I am not challenging those part of the exercise of the authority. Only I am saying, my lord, the exercise of any statutory provision, my lord, by the statutory authority, my lord, when exercise on bait, my lord, that is illegal, my lord. Bait in law, my lord.
What is the bait?
Bait, my lord, two aspects. What, my lord, on the report, my lord, will see, my lord, in Bombila, my lord, there is as much as 1,000 unauthorized unauthorized occupant, my lord, and those are on the record of their land department, my lord, who have submit their application, my lord. That is on the record, my lord.
So they have not been issued eviction notice.
No, my lord. I will not go on to the negative equality of the concept, my lord. I will not argue on that, my lord. But what I am submitting, my lord, this is a necessary pay, my lord. In Bomdila, my lord, as much as more than 100, my lord. Now, complainant, my lord, laws a complainant, my lord, saying that I am not indigenous of that district, my lord. Initial action, my lord. How initial action? Initial, it say, my lord, I am not indigenous, my lord. I have no right of land allotment in Bomdila, my lord. On that complaint, my lord, the statutory authority acted upon, my lord. Now, that complaint itself, my lord, is violation of Article 19 F, my lord. Now, my lord, when the initial process, my lord.
Are you against the complaint or what?
My lord, I am against the complaint and, my lord, the subsequent action, my lord, using, my lord, taking the veil of the law, my lord, to pass a eviction order against me, my lord. Now, statutory authority, my lord, ultimately, my lord, my lord, where my lord, we have regard to judicial and quasi-judicial authority, my lord. It's the independent, my lord, independent of the.
Any order passed under the section 6, under section 6 is applicable.
No, my lord, that is not applicable, my lord.
Then what is to be done
Not applicable.
if it is not applicable?
My humble submission, my lord, this case, my lord. My humble submission, my lord, if my lord, this can be list of proper hearing after vacation, my lord.
What properly? We'll hear you properly.
Today, my lord, I may be not able to properly assess this, my lord.
We understand the difficulties. You have already constructed huge building,
My lord.
but facts remain that you are unauthorized occupant.
That,
have to be
yes, my lord,
evicted.
I conceded, my lord, but if this case maybe my lord, interference, my lord, in my lord, hold the exercise, my lord, the statutory authority, my lord, is to ultimately is, the society, my lord, the citizen regard the quasi-judicial authority, my lord, due to its independence, my lord. There should be some application of his own mind, my lord. Now, here is a case, my lord, this statutory authority, my lord, acted against me alone, my lord, under the dictate of the third party, my lord. It not the case, my lord, this lane, my lord, is required for public purpose, my lord. It not the case, my lord, this lane, my lord, disturb any public activity, my lord. Only on the complaint of the private respondent, my lord, the statutory authority, my lord, to satisfy their complaint, my lord, use the statutory law, my lord, against me, my lord. No, my humble submission, my lord, that is really in bait paid, my lord. When the statutory authority pass any order, my lord, though within his jurisdiction, my lord, in bait paid, my lord, that is bait in law, my lord. So my humble submission, my lord, yes, today I may be not able to assess this honorable court properly, my lord. This case.
No, you are assisting properly. Listen, you'll have to go. Section 4 notice was issued.
Section 4 to section 6 was issued, my lord.
Section 4 notice was issued. You have replied and you were heard,
My lord.
and then the section 6 passed.
True. That is true, my lord.
Unless you show that you have the right to be considered for allotment, I think it's all illegal.
But surely, my lord, illegality part, my lord, I have, and I maybe have no, that I consider, my lord, I cannot go for
If you consider
negative equity. That's why, my lord, my submission, my lord, my forward, my lord, this bill listed after vacation, my lord.
on the prayer of Mr. El Permit, Land Council for the petition, and prayer not being opposed by, no, on the, not being opposed by Land senior government, Mr. S. This matter after 4 weeks. 4 weeks. They do. listed. What is this?
My lord, CRP. May I please, ma'am?
Yes.
My lord, I have filed an execution petition before the ADC, my lord,
Hmm.
for the execution of the Kabang order, my lord.
Yes.
Accordingly, my lord, execution order has been passed, my lord. My lord, execution order is at Annexure 7, page 40, my lord.
Page 43. 43.
Page 40, my lord.
14.
41. 40. Tab copy is 41, my lord.
Hmm.
May I read, my lord?
Hmm.
Whereas an execution petition has been filed by the permanent resident certificate holder of Mabo Village, so the applicant who is represented by the Learned Council, Mr. So and so. The applicant has filed the execution petition under section 45(2) of the Assam Frontier Administration Justice Regulation Act 1945, read with Order 21, Rule 35 of the Code of Civil Procedure 1908, for the execution of Kabang decision dated 23/10/2023, held in continuation of the Kabang dated 20/10/2011 and 30/07/2014, to the vacate the disputed land, namely Merbo Moruk, by removing any persons bound by the order dated so and so, so and so. And whereas, as per the record, the village authority has corroborated with the Kabang decision of 20/10/11, 30/07/14 and 23/10/2023. Further, no appeal has been prepared against the aforesaid Kabang. And whereas, on a perusal of the record of the Kabang held on 20/10/2011, 30/07/2014, and 23/10/2023, it has seen that the land in question, that is Moruk area of the Merbo, is a community land of Merbo village as per the Kabang decision. Now, therefore, the execution order is issued under the provision of subsection 4 of section 2A of Arunachal Pradesh Civil Code Amendment Act 2022 to the judgment debtor. That is the
How you
government.
are aggrieved?
Yes, my lord.
How you are aggrieved?
My lord, accordingly, after the past execution order, my lord, there is a complaint, my lord,
Hmm.
which has been, there is a complaint filed before the ADC, my lord,
Hmm.
by the respondent herein, my lord. And the same complaint was treated as my appeal, my lord. Thereafter, the impugned order has been passed. The impugned order is, my lord, page number 19, my lord.
This execution is in your favor,
Execution is in my favor.
in your favor.
Yes, ma'am.
Moruk, possession of Moruk area so to be Mebo Dolung Kebang.
Yes, ma'am. This is community land.
So
Accordingly, after the receipt of the complaint, my lord,
Hmm.
the ADC has stayed a execution order earlier passed by him.
Appeal against whom? Appeal against the execution order.
Yes, my lord.
Appeal has been filed against the execution order before the same ADC.
Yes, my lord. Same ADC.
Heard Mr. M. Doji, the counsel for the petition. This revision petition has been is preferred. Assuming the order dated 31/05/2024 passed by the Additional Deputy Commissioner, East Siang District, Mebo. This is 11 June. Impute order is 11 June.
Yes, my lord. Subsequent, there is subsequent order, my lord. Last annexure
So
8, my lord.
why you have mentioned 31/5/2024? Where is 31/5?
31 pipe is my lord. 31 pipe is impugned, my lord.
Where it is?
There are annexure 1, my lord, page number 19.
Where is 31/5? Page,
19, my lord. 19.
what is this?
This is the order whereby the earlier order, execution order has been stayed. my lord.
Okay, this 11/6 is continuation.
Yes, the hearing was fixed on 11/6/2024. However, the same was
31/05/2024 passed by so and so. Not 31.
however, the same was not conducted on that day, my lord. Accordingly, the subsequent order dated 11 June 2024 has been passed.
And orders 31/5/2024 and 11/06/2024 passed by the Additional Deputy Commissioner, East Siang District, Mebo, whereby the execution order dated 29/02/2024 has been kept in abeyance till the disposal of the appeal made by the respondent.
Yes, respondent hearing.
Issue notice returnable by 4 weeks. The learned counsel to the petitioner to take steps for service of notice upon respondent number. The sole respondent by registered post to the AD. Within 2 days from today. comma. what is to be done? Suppose if you stay, there will not be proceedings.
My lord,
In that case, you have to maintain the status quo.
my lord, operation of the
The
impune order may be-
operation will stay, but
Yes.
you have to maintain the status quo. Otherwise, execution, it will amount to granting you, once this is executed,
Yes.
until disposal, amount to granting you the position. Maintain the status quo.
Yes.
Consider, heard on the interim prayer. Next prayer. Considering that the ADC, the ADC member ought not to have entertained the appeal against the execution order dated 29/02/2024. Passed by him comma, the impugn orders dated 31/05/2024 and 11/06/2024 hereby state, Mr. The parties to maintain status quo till the final disposal of this revision petition. This after 4 weeks.
Okay.
Yes, we'll dispose it of.
My lord. My lord will kindly turn to page number 34, my lord. This is the impugn
34.
advertisement, my lord.
Who are you?
I'm my eligibility, my lord, is not disputed, my lord. I have any whole documents, my lord. I'm eligible to all the posts, my lord. We are eligible to all the participate in all the posts, my lord.
Yes,
We are eligible to participate in all the posts, my lord. That is
all,
not disputed.
including junior engineer.
Oh, including all the posts, my lord. That
Okay.
is not disputed, my lord.
Yes.
We have annexed the documents also, my lord.
How many of you?
We are 2 in number, my lord.
Okay. Yes. Then,
My lord will kindly turn to page 34, my lord. This is the advertisement, my lord.
yes,
And my lord will see this is the 20 August 2021, my lord. Application are inviting to fill up few earlier it post was not mentioned for few vacant posts of junior engineer, surveyor and junior engineer on contractual basis for a period of 6 months in Water Resource Department, Government of Arunachal Pradesh through WAG in interview, my lord. This is my lord, you can note this only, my lord. This is the inter. There the it page number 35, my lord. 35, my lord. Subsequently, my lord, posts were mentioned, my lord. Specific posts, my lord. Junior engineer 7 posts, surveyor 4 posts, and junior estimators 2 posts, my lord. Now, as my lord, I will specifically deal with post wise, my lord. First, I will place relevant, my lord, recruitment rule on
Yes.
place about the particular for JE, my lord. For JE, my lord, will kindly turn to page number 45, my lord. 45, my lord. 45, my lord. This is, my lord, notification pertaining this, my lord, for July 2017, my lord.
yes,
I am reading, my lord, this. The governor of Arunachal Pradesh is pleased to authorize the Arunachal Pradesh Public Service Commission to conduct recruitment of all Group B posts, non-gazetted posts under the Government of Arunachal Pradesh. The recruitment of Group A, Group B gazetted shall continue to be recruitment to the Arunachal Pradesh Public Service Commission. The present practice of conducting, my lord will kindly endorse. The present practice of conducting recruitment by appointing authority themselves shall be dispensed for with, my lord. This, my lord, kindly note, my. This is the intent by this annexion, my lord. And at paragraph 7, my lord, will kindly see last paragraph.
recruitment can still be.
last para, my lord, this page, last para, my lord, is same, one, two, three, last fourth para, my lord. The recruitment, my lord. My lord,
Candidates shall be made through as well, so,
through a written personal interview. My lord will note this, my lord.
yes.
Now, yes, my lord will, for the moment, kindly take up my additional epidemic. I have placed the recruitment rule of this JE, my lord.
Hmm?
My additional, sorry, my lord, I have
So
filed one,
there's no dispute, it has to be written by,
my lord.
is that it?
Yeah.
What is recruitment, what is additional?
Additional epidemic, my lord. I have an in additional epidemic at page number 19, my lord. I have placed in at page number 19, my lord. This is a. It start from annex number 3, page number 16. This recruitment rule, my lord, frame under Article 309, my lord, pertaining junior engineer, my lord. The relevant part I want to indicate, my lord, at page number 19, my lord. 19, my lord. 19, I want to indicate.
There are two additional affidavits. One is by the government.
I'm
Government has also filed additional affidavit.
my lord, my lord. I'm on my additional epidemic, my lord. My additional epidemic, my lord, page number 19, my lord. This is a part of the recruitment rule part to the post of JE, my lord. Page number 19, my lord.
Junior engineer. Hmm.
Page number 19, column 11, my lord. It serial number 3, it indicate for direct recruitment, written test followed by Viva will be conducted, my lord. That I want to indicate, my lord.
Page
19, my lord. 19. It's serial number 3, my lord. It's say, my lord.
direct written is followed by Bubushi. Huh?
Now, my lord,
Yes.
one thing also, page number 19 or 16, my lord, back to the same 16, my lord. My lord will 16, my lord. Important page I will indicate, my lord.
Yes.
Here, my lord, at page number 16, it's a power to relax, my lord.
Hmm.
Power to relax, where the governor of Arunachal Pradesh is of opinion that it is necessary or expected to do so, he may, by order for reason to be recorded in writing, in consultation with Arunachal Pradesh / Public Service, Arunachal Pradesh Selection Board / Public Service Commission, my lord. That is, I find important, the consultation of this board in case of exigency, my lord. Now, my lord,
They are not relaxing anything.
now I would indicate my on for this recruitment process, my lord. The government, my lord, say, my lord, this is necessary, my lord. In their own record, they are saying this is necessary, my lord. In case of my lord, this interview, my lord, this is necessary, my lord. I'll indicate it in later on, my lord. Now for group, my lord, for surveyor and junior engineer, my lord.
Recruitment rule says what? It should be conducted by whom?
Conducted by the for JE, my lord, APPSC, my lord.
No, now.
Now, my lord,
And
APPSC.
as per rules,
It earlier it was, my lord.
as per rules,
It is a by the department, my lord, SE, SE, my lord.
hmm,
Their appointing authority is SE, my lord, superintendent engineer, my lord, for
So-
JE, my lord.
has it been amended? Has it been amended?
No,
If not amended, how can by way of your office memorandum
my lord,
can be sent to?
my lord, that is other aspect of the matter, my lord. That is not under challenge, my lord. Now, my lord, what? No, that is not amended, my lord.
No, you are basing on the office memorandum. Is it a rule which you have shown in page 9? Sorry, page, what is that page?
Page number 45, my lord.
45.
Recruitment, recruitment rule, my lord, prescribe, I think it prescribe no particular, my lord, authority to be conduct a recruitment process, my lord. But it's there is a appointing authority, my lord. Appointing authority prescribed for J, it is a superintendent engineer.
Is this rule still there?
This recruitment rule, my lord. I believe it still this still hold the field.
1994.
Holding the field, yes, my lord.
Yes.
Now, other for the post, my lord, of junior, sorry, my lord, surveyor and junior estimator, my lord, the relevant fact I beg to indicate it at page number 51, my lord, of read petition, my lord. Sorry, it starts from 50, my lord. 50, my lord, 50. Annexion number 6, my lord.
Yes.
This is a Arunachal Pradesh Staff Selection Board Act 2018, my lord. Now, relevant particular part I beg to indicate it is page number 51, my lord. Page number 51, my lord, will see it, this is definition part, my lord. This is section 2. O, my lord, will see my, O, my lord. O means, my lord, subordinate service post means Group C post in the government, department, organization, and autonomous body established, constituted by the government and semi-government organization, and include such service post A may be notified the government to be subordinate post, but shall not include tenure post which are created for posts. Thereafter, my lord, will kind it, it's 6-4, my lord, 6-4, my lord, down below, my lord, page 50 and 6-4, my lord. 6 section 6 rule 6 or section 6-4 say, my lord, notwithstanding anything contained in any other law for time being imposed or rule regulation by
So
law.
surveyor and the estimator shall go to SSB.
SSB, my lord. Now this rule for say law for time being imposed rule regulation by law framed thereunder related to appointment to the service post in and condition of the service employed, the government department, organization, and autonomous body established, constituted by the government and semi-government organization. The board shall be the authority, my lord, kindly, no, the board shall be the authority competent to conduct exam in for appointment to the subordinate service post / post of such.
It's okay, there's no dispute.
Now, my lord, will kindly note this also, my lord, at page number 55, my lord. 55, my lord. Now, in terms of this, this rule has been framed, my lord. This is Arunachal Pradesh Staff Selection Board Rule 2018, my lord. Now, a definition part 2, my lord. The thing I want to indicate, my lord, is 2C, my lord. 2C, contingency casual worker. Mean worker engaged by the department from time to time against daily or monthly work, my lord. Thereafter, my lord, D, my lord. D, contractual post, my lord. Means a post created or a specific job is specified rate by paying having functions similar to subordinate service post or fixed on pay scale and specific time. Now there are two K, my lord. K is important, my lord. Post, my lord. Post means subordinate service post as defined under 2O of the Act and include, my lord.
There's no dispute, it's okay.
And now,
Are they disputing?
no, my lord, they are trying to project, my lord, this is contractual, my lord, this regulation, my lord, rule will not applicable. Now, I will say, my lord, the definition of post, say, my lord, and include contractual post also, my lord. Now, in terms of this rule and act, my lord, even for the contractual post, my lord, The recruitment authority, my lord, is, my lord, the SSB.
These are regular posts, not contractual.
Yeah, my
They
lord.
want to appoint it, recruit it for some time
Yes, my lord.
on contract basis.
Contract
It's
basis.
not a contract post.
My lord.
Contract post would mean
No.
when it's created for a particular period.
My lord. But even,
To appoint a person on a regular post for a period of for certain period on contractual basis, it would not be a contract post.
yes, my lord.
So therefore, there is no dispute. They cannot say that this is not a contract post.
Now,
They can say the contract post. It's a regular post wanted to appoint on contractual basis. Yes, it's okay.
now, at page page number 66, my lord, last page, my lord,
Over here,
already
it's okay.
I've indicated, my lord. Now, therefore, my lord,
As of now, I am with you. It's
Well,
okay.
now,
I agree with you.
now, as per, I am saying, my lord, they have no authority, my lord, under the law, my lord, to carry out this recruitment process, my lord. Pass, my lord. They have no authority, my lord.
Okay.
Now, even, my lord, assuming they have authority, my lord, there is go executive, my lord, can relax this rule, my lord. Then also, my lord, this should be the competent. They have filed an affidavit saying that they have taken the authority, my lord. Now they have
They have
there is
taken
a
a what?
or they
Approval.
approval, my lord.
Approval from where?
From they are saying they have taken the approval from the competent authority, my lord. Now my humble submission, my lord, that is that statement, my lord, is contrary to the record, my lord, placed in this case, my lord.
No, there is their official procedure. Once the approval for appointment, they may take it, but then if it is contrary to the rule, you can.
Now therefore, my lord, there
It's
is
okay.
there still, my lord, there.
Unless they say something and show something.
My lord,
I'm
before
with you. It's okay. Yes. There's no dispute.
Our case is very simple. This is vacancies. We have
It's a regular vacancy.
regular. We have requested the recruiting opportunity. So this and what it was that we can make. And there's some delay. And in the meantime also we are running sort of manpower. Just to fill up this gap in the industry, on the ground of just to fill it for time being okay. This is only our simple case. Now question comes for this particular process, the selection process, which we have adopted, this is contractual. For that, these act and rules doesn't apply laws. For that lawsuit, whether we have the power or not, we have our that one office memorandum laws. In case of administrative agency laws, it's not that lawsuit we are filling up that with that scale law. The post years lawsuit scale, but which we have proposed lawsuit is a particular considered fixed amount of 20 lakhs, 15 lakhs, 20,000, 15,000, and 50,000 for three categories. Fixed lawsuit. Here also we are not filling up those posts permanently. Therefore, until we propose for that filling up that post with that scale for in the nature of permanent basis law. The applicability of these rules and all doesn't apply laws. For applications of these rules, we have always forwarded to the laws recruiting.
When? Can you show that?
My affidavit, one affidavit was filed by 2 and 4.
1, 2, 3.
1 to 3 is yellow, 2 and 4 also filed.
Who is 2 and 4?
And prior to lawsuit from on the ground of lawsuit delay lawsuit, we have taken concurrence from the financial department, finance department also, so that we for this time being also just we want to finish that. Then approval was taken from the finance department, even the opinion of the administrative report was taken. After all those approval, we proceed for this Lawsuit come to page lawsuit 21. Page 21. Annexure 5. This is a reminder law. Otherwise, it was same on lawsuit filed in reference law. 12/8/2020.
Where it is?
Page
Page of
This
21.
affidavit filed by respondent number 2 and 4. 2 and 4.
Not the additional.
No, that is the affidavit.
Affidavit in-
Okay, this is extra affidavit only. I'm sorry.
Additional affidavit.
On phone process page is written in operation lawsuit, but in lawsuit,
Filed by Tagerumi,
respondent number 2 and
4th,
4.
4th of April.
This is filed for 9 August 2020.
22
Oh,
April. This additional is being compliance.
this
Then
is extra affidavit.
so many additional
This
affidavit.
is, two additional affidavits are from the government side.
16 August, 9 August. Yes.
9 August.
Hmm.
Page can come page equal.
Annexure. Twenty-one, yes.
This lawsuit, second, lawsuit, we are asking for this.
Hmm.
The lawsuit filed in the secretary of College College Policy, the status of recruitment against Indian citizens. Reference lawsuit, 12/8/2020. By this letter, we have lawsuit asked for the level and
Just wait. Page 21.
page.
The status of recruitment process, yes.
This is the letter, reminder letter, written to the Public Service Commission by the department. In reference lawsuit, we have asked for requisitions, recruitment on 28/2020. And on next page, lawsuit filed, we have written letter to the lawsuit, Public Policy Staff Collecting Board. Since these two are not party in this lawsuit. So therefore, the exit difficulties why they are not recruiting lawsuit. So for APSC, Public Service Commission is consulted.
The department who is filing this affidavit, they should also go get it.
Guidelines. Hold by the state government. This government is a body law. It's a liberty to lawsuit, have employ someone on contractual or temporary basis. The power lawsuit that cannot curtail law because it's in the interest of public. Office memorandum of 1994 law. I have given the two office memorandum. This is the 1994 office memorandum is a lawsuit.
Is it still,
Is still lawsuit. 94 has been lawsuit re-end of in 2000 lawsuit. Both the office memorandum.
Sorry, my lord, I was not given
What
privilege to have a look at that, my lord.
what
This is not a matter of record.
No, it
not-
was given to you, so I think it's must be there.
No, my lord, this is, a report, my lord, cannot be, this record cannot replace giving by personal, that should be the record of form affidavit, my lord. I have not given, my lord, such a record, my lord. So I can have a say on
this
that,
is
my
with
lord.
regard to contractual?
Contractual. It lawsuit see it as of 94 office memorandum. This is the lawsuit instruction, how the lawsuit, in case of lawsuit, how the lawsuit contractual agreement has to be made. Sound has to be fixed until further or yes, no problem. Contractual must be for a specific period.
Yes.
So,
2000 where it says? In 2000?
2000 lawsuit, to the last page. Last page,
Same may be made on exceptions when it is for absolute condition.
Almost I think we are clear. Now only question was
Hmm.
when this recruitment process is going on. In the meantime, if you want manpower also, you have the power to proceed to have political appointment. I'll place three judgment also. So to be decided. They are 1993.
Year 19.
AR 1953, SC 250.
Yes.
Period of 30 years.
Yes.
Generic. The Article 51 is equal in applicable. The whole matter rests in context. When the petitions context first.
What is this?
Period.
AR 19
AR 1953.
Supreme Court 250. Para 13.
13.
It's when the matter was first argued. Yes. What is that from? The word sister?
This is Satish Chandra Anand.
Yes.
Satish Chandra Anand.
Hmm. You para start from which word?
Article 61.
Yes. Para 11.
Yes, I'm sorry to say.
Must be Supreme today.
It's a SEC online list. Article 51 is equally inapplicable. All matter rests in context. When the petitioner's first contact, the 5-year one, came to an end, he was not a permanent government servant, and government was not bound either to re-employ him or to continue him in service. On the other hand, it was open to government to make him the offer it did of a continuation of employment on a temporary and contractual basis. Though the employment was continued, it was in point of fact and in eyes of the law under a new and fresh contract which was quite separate and distinct from all, even though many of its terms were the same. Article 51 deals the equality of opportunity in all matters relating to employment or appointment to any office under the state. The petitioner was not even denied any opportunity of employment or appointment. He has been treated just like any other person for whom an offer of temporary employment under these conditions was made. His grievances, when analyzed, is not one of personal differentiation, but it is again an offer of temporary employment on specific terms as opposed to permanent employment. But of course, the state can enter into contract of temporary employment and impose specific terms in each case, provided they are not inconsistent with the Constitution. And those who choose to accept those terms and enter into the contract are bound by them, even as the state is bound. When the employment is permanent, there are certain statutory guarantees, but in the absence of any such limitation, government is subject to qualifications mentioned above, is free to make special should contain a service with temporary, temporary engagement, what also influence. Now, what just I'm pointing out was, here also the whether government has this liberty to also have contextual employment or not. One also
But
by plotting this
But not. not-
inconsistent with the constitution law.
It has to be in consonance with the recruitment rule, as per the rules.
Laws.
The
Here,
rule requires written examination.
law,
Even it
laws,
was contractual.
that is for lawsuit, the lawsuit. Well, that's what I'm pointing out, lawsuit. If suppose say this is for the permanent post lawsuit, permanent employment lawsuit, then recruitment rule has to be followed lawsuit.
No. For temporary, for
If-
contractual also you have to follow. Apart from why you are the competent recruiting authority or not. It's our own office memorandum, 94, 2000. Now things has changed. The state has realized that this cannot be permitted.
Lawsuit, to my understanding, lawsuit. Because contextual and then the permanent lawsuit. And those conditions prescribed in the recruitment rules lawsuit. That is mean for the permanent recruitment laws.
Yes.
What I understood was. Here, we are not opting for that, but we are
How
making,
can you do that? You cannot recruit them.
now,
Now you cannot recruit them.
so therefore here, lawsuit, the government is
No, if you have the power to appoint on contractual basis,
lawsuit.
it has to be in accordance with the rules. Rules prescribe
Lawsuit.
written examination followed by a BIBA.
Lawsuit.
So you do that.
No,
If
that-
you can
no.
show that there's an accident.
that guidelines lawsuit, that I have just placed OM lawsuit. This is the only guiding principle lawsuit available in the state, in respect of the employees under the state of ownership parties lawsuit.
What?
This office memorandum lawsuit. Apart from lawsuit, so far contextual appointment is concerned
Each
lawsuit.
Case of appointment contract service shall be dealt with independently. Based broadly on the state guidelines and agreements will invariably made between the employee and the. Entire.
There are two sets of recruitment. One is a contextual lawsuit, other one is a permanent lawsuit. So far permanent is concerned lawsuit, that recruitment rule was only their lawsuit. We are not touching those lawsuits. That we have left to the recruiting authority. law.
That is the problem.
And no,
If you are not following the recruitment rule, how you can allow?
our objective lawsuit. Objective is completely different from
Your
each.
objective is pick and choose.
Lawsuit. Advancement is open to everyone lawsuit. Even the petitioner can participate lawsuit.
Therefore, there is a scope of pick and choose. You apply the rules. You
Lawsuit,
appoint them through written and BIBA, maybe on 2 days or 3 days.
but for lawsuit, that contextual recruitment lawsuit. This written and all has to be followed lawsuit. That is lawsuit.
That has to be. Only because there's a scope of pick and choose. That cannot be allowed. If you want to go for a limited period by following the rules, in view of this guidelines, we may allow you to for a particular period. Say 6 months or till the
Then
recruitment.
lawsuit, this matter may be disposed of with that observation. Otherwise, the
No, we'll
rest,
set aside the order, advertisement, and liberty will be given to, on the administrative side, till the, if the authority finds that in the administrative exigencies, a post has to be filled up till the recruitment, regular recruitment process. Will give you just liberty. There has to be in accordance with the law, accordance with the rules. Rules means followed the written test followed by Bibles.
that observation is made, then lawsuit.
But you will set aside this.
Okay, no issue.
Only liberty is given. We are not directing you to appoint.
No.
In case If there is exigencies,
That is their lawsuit, because this process lawsuit, it takes time lawsuit. Therefore, we have adopted this
or
lawsuit.
any other judgment, only this much.
Only two more judgments are there lawsuit.
What is
Here
it?
also
What-
only the
what does
power
it say?
to have the contractual appointment lawsuit.
Hmm.
1997 for SSC 348. Here lawsuit may not lawsuit, paragraph 9.
Hmm. There is.
If lawsuit, see the paragraph 9 lawsuit. In here what happened lawsuit? The petitioner already, sorry, or person already superannuated lawsuit. Further continuation was the issue lawsuit. Then under contract lawsuit, it was continued lawsuit. And this one of court lawsuit said lawsuit is permissible.
Where it says.
May I read lawsuit? On the, I'll read from the lawsuit paragraph page 355.
PK Chandu.
PK Chandu. PK Sandu.
Ah.
Page 355 lawsuit. The further contention in the second line lawsuit. Second line after police stop lawsuit.
Hmm.
The further contention that availment of the services of the General Secretary on contract basis is invalid, is without substance. It is settled legal position that an in-service officer, if taken on contract basis during the period of service, renders services on contract basis, and on expiry thereof he gets to his substantive post in the parent department from where he came to be in services of the Lok Sabha Secretariat. In the interregnum, he cannot be compelled to lose his lion on the substantive post in the parent department. Even if the services of an incumbent on superannuation is required in the public interest, the same can be able on contract basis. Equally, if any other competent officer who on attending superannuation from any other service was required to be taken in due to exigency of service, it may be open to the speaker to able of services of such an experienced officer on contract basis for a specified period. Thus, in either even the options available to speaker to able of the service.
Not relevant.
No, sir?
Not relevant. Next.
Lordship,
You try to show that the authority has the power to take on contract basis. That is what.
contract basis, on the ground,
This is a case when the man was taken on contract basis,
No.
was serving is somewhere on deputation.
here, Lordship, what observation has been made, Lordship? After superannuations, Lordship. So far, this interregnum, that was Lordship, when he was in Lordship, he was taken from the parent department on deputation, Lordship. That's another thing, Lordship. And second leg is there, Lordship.
What?
After superannuation, Lordship, his service can be Lordship taken on contract basis. Lordship.
Yeah.
That's the I am on the second leg, Lordship. Third one is Lordship 2 times 6, 11 SEC.
Yes.
Page 731.
750.
731.
731. Yes.
Paragraph 75.
Hmm. Retired armed forces. Yeah.
Lordship, yes. Kindly come to page 762, Lordship. The relevant Lordship. Paragraph 75. Paragraph 71, Lordship.
75.
I lost it. The contractual appointment oblique power of the government. Mr. Raju Ramachandra, learned senior counsel appearing for the trade union, clearly considered that the government has unrestricted power to make contractual appointment. Even otherwise, the government, in our opinion, has the undoubted power to make a contractual appointment until further orders. the finding of the finding to the contrary is expressly erroneous. The second is lordship, the observation law. Then paragraph 80, 81 and 82 lordship. '81 and '82 lawsuit is a reference of the Satish Chandra Anand and P.K. Sandhu lawsuit. In P.K. Sandhu lawsuit, if lawsuit see the paragraph 82, power to make an appointment includes the power to make an appointment on substantive basis, temporary or officiating basis, ad hoc basis, on daily wages or contractual basis.
No, therefore, you don't have the power to make appointment without going through the proper selection process.
Lawsuit, just what I'm pointing out, lawsuit. This so for recruitment rule, as I'm not disputing lawsuit. The
Yes, it's okay. Or Mr. Elper, counsel for deputy.
Yes, my, this is important page, my lord. In the report of dear epidemic, my lord, I need to indicate this, my lord. Only one page, my lord.
Yes.
They repeatedly they are saying, my lord, for approval, my lord, was taken for this whole process, my lord. That is, my lord, totally contrary to the record, my lord. My lord, kindly have a look at 20A of additional epid, my lord. Proposal was not approved, my lord. Proposal to carry out this whole process, my lord. They are rejected, my lord.
Where they approve that?
Only for in the 2019, it is per the record. In the year 2019, yes, for 6 posts, my lord, they have 17 posts. They have taken approval of finance department. But how to carry out the recruitment process, my lord? That was again posted ultimately by 2021, my lord. The ultimate direction, my lord, by the this is by the Department of Administrative Reform. What they say, my lord, the proposal of department has been examined as per the record available in the file, and observed that the role of department administrative reform is limited. Recruitment to direct category, etc., is to be made as per the rule prevailing in the date of occurrence of the vacancy. Through Arunachal Pradesh Public Service Commission in a group B service and above the in Arunachal Pradesh staff selection board in case of group C post service as prescribed. In case of operational, my lord, problem exigency, the competent authority can approve relaxation in prescribed mode of recruitment rule under the relaxation clause in recruitment rule as class or category. Now, this is the final observation. The appropriate action may be taken by the department according to consultation of finance department. This issue with the approval of secretary of government department administration. This is the ultimate, my lord, final thing. They have annexed, my lord. Now, this department suggests, my lord, you need to consult with the board as per the recruitment rule. Now, board is for the JE, it is APCS, my lord, and for the other post, my lord, service board, my lord. Now, thereafter, my lord, the pilot end on 25 to pilot end of the SE, my lord, the advertiser issue, my lord. No approval was taken, my lord. This is contrary, my lord, their statement, my lord. Approval was taken, my lord, is contrary to the record, my lord. No approval was taken in this case, my lord. They themselves, the advice of consultation with the board is required.
Lawsuit, on this point, lawsuit, is more clarification. If lawsuit see the
We're not going to all this thing.
okay, then only I pray for that liberty and observation lawsuit.
If permissible under the law.
Lawsuit,
If
by
permissible
following the
under
lawsuit, retain and by lawsuit, if that observation is made lawsuit, equally it will be lawsuit applicable to everyone lawsuit, including the petitioner lawsuit.
No, my lord.
Everyone will have liberty to losses, appear in exam losses.
No, my lord. If any
Only our apprehension is the losses. If Viva was only is adopted losses, then there's chances of losses favoritism.
in
To do away that losses, so that's a mind of this one of losses. I can understand losses.
my lord, in any condition, my
Pursue the recruiting agency, commission and the board
Losses here one thing.
to
Losses.
recruit.
Here one thing losses.
Yes.
We have been writing to the authority losses, and we don't have any control over them losses. There's a difficulties on our part, and at the same time, losses, in this of the state losses, public interest demands losses, we need manpower losses. But the government has to run losses without manpower. That aspect has to be seen losses.
my lord, my humble submission, in any circumstances, my lord, in the last, this was approved for 6 months in the 2020, my lord. Any order cannot be passed
Then
to.
they stay.
Is order is there, but
Therefore,
nothing.
they did.
No, my lord, for their, my lord,
It's okay. I've
therefore,
heard
my
it-
lord,
heard
any
you
order,
enough.
they can misuse, my lord. They
And
can say, my lord,
Heard Mr. Elper learned counsel for the petitioner, and also heard Mr. Estafet learned counsel for the learned senior government advocate for the state respondents. There's no private respondent, I suppose.
No
no,
problem.
liberty will, my lord,
Expect-
only will in the, if.
I'll see
yes,
to it. Let
only
me-
if
Let me
law permit,
decide, let me decide. Challenge made in this writ petition is to the advertisement being number, page 34, huh? Dated 2008-2021, issued by the superintending engineer within bracket CORD, COORD, bracket close, Water Resource Department, comma, Chimpu, within bracket Itanagar. Page 34, huh? Inviting applications for filling of few vacant post of junior engineer within bracket civil, bracket close, surveyor, and junior estimator on contractual basis for a period of 6 months. Through walk-in interview on consolidated salary of rupees 20,000 for junior engineer and rupees 15,000 for surveyor and junior estimator per month. And also the addendum dated 24/08/2021. Whereby the number of posts are indicated as for junior, 7 posts for junior engineer, 4 posts for surveyor, and 2 posts for junior estimator in continuation with the opposite advertisement. List of the you are graduate or what? Engineer graduate.
yes, my lord.
The petitioners. 2 in numbers, comma. Petitioner, comma, 2 in numbers, huh? What is your qualification? Are you eligible?
Yes, then, my lord.
Diploma. Yes. Page 36, diploma, and Other one is Bachelor of Technology, Civil Engineering. Two in numbers, huh? Or diploma holder in civil engineering and BTech in civil engineering. List of. They are eligible. No, the petitioners are eligible to be eligible to participate for the post of junior engineers as well as junior engineers and other posts advertised in the advertisement. Mr. The contents of the petition is that the department is not empowered to recruit and appoint the post of junior engineers as well, junior engineers, comma, junior engineer, comma, surveyor and junior estimator as the recruitment has to be, the recruitment to these posts has to be through the Arunachal Pradesh Public Service Commission and Arunachal Pradesh Staff Selection Board. List of. The recruitment rule provides for the, no, before that. The post of junior engineer is a group B within bracket non-gazetted as per the recruitment rule. And the post of surveyor and junior estimator are group C post. List of. As per the notification, which notification conferred that? Notification dated 04/07/2017. The government has authorized the Arunachal Pradesh Public Service Commission to conduct recruitment of all Group B within bracket non-gazetted bracket clause post under the government of Arunachal Pradesh. It has also done away with the practice of conducting recruitment by appointing authorities themselves. And the conduct of the recruitment examination for the Group C post, Group B non-gazetted post shall be made through the Public Service Commission only in the first page. It also provides that the recruitment of candidates shall be made through a written examination and personal interview conducted by the Arunachal Pradesh Public Service Commission. It shall conduct the written examination at the various examination centers, either online or offline. The commission shall frame set of examination guidelines for conducting the examination for recruitment of officials at various levels in the most transparent manner. It is contended that there exists a set of guidelines framed by the Arunachal Pradesh Public Service Commission for conduct of such examination and are being conducted, and the Group B post within bracket non-gazetted are being conducted by the Public Service Commission. Then what is that next para? It is further contended that on the enactment of Arunachal Pradesh Staff Selection Board Act 2018, the post of surveyor and junior estimator falls under the Group C. Group C. It is the board, the Arunachal Pradesh Staff Selection Board, who is the competent authority, is the authority competent to conduct examination for appointment to the such post. Mr. Mr. Elper Lamet, counsel for the petitioners, while referring to the notifications dated 04/07/2017, the Arunachal Pradesh Staff Selection Board Act 2018, as well as recruitment rules regulating the recruitment and appointment of junior engineer, the post of junior engineer and surveyor and junior estimator, submits that the impugn orders inviting applications for filling up the post of junior engineer, surveyor, and junior estimator is against the recruitment rule, notification, the act and the act and rules in vogue. He submits that he submits that advertisement, impugn advertisement that 20/08/2021 clearly indicates that the posts are to be filled up only through walk-in interview, of course, for contractual basis, list of which shows that such an recruitment only through walk-in interview would not be transparent. Mister. It the is likelihood of nepotism and favoritism in appointing through walk-in interview. Mister. The rules provides for written examination followed by Bible version, which cannot be no. Since the rule provides for walk-in interview, written examination followed by Bible version, the impudent advertisement, which provides only to a walk-in interview, is against the recruitment rule holding the field list of. We are regulating the post-advertised list of. Next paragraph. Mr. L. Leonard, Council, submits that. Leonard Council, while referring to the, what is that rule? Relaxation, power to relax.
Power. Additional, in term of JE, my lord, in additional epidemic, my lord. In my additional epidemic, my lord. At page number 19, 19, my lord.
Why this running page has not been done here?
Lord, when I filed, my lord, I was not given this recruitment rule, my lord.
No, it has to be done by the office. Additional affidavit. Page
16, my lord, 16.
in all the rules, it's page. This is junior engineer.
For junior engineer is 16, my lord. In for other post, my lord, I have annexed in my read petition, my lord.
Where it is? Referring to the rule 6 of Junior Engineer Recruitment Rules 1994. And where else? Where else?
Page 59, page 59, my lord. 59 of read petition, my lord. Power to relax.
This is
For group C category, my lord. Both.
and rule 19 of Arunachal Pradesh Step Selection Board Rules 2018. Come on, submits that. Unless the power to relax, the power of relaxation of the rules is invoked by the responding authority. Come on. No appointment, no recruitment or appointment can be made by the responding authorities which is in violation of the recruitment rules
Lordship, may I
applicable
make
there.
one small correction? Also?
Yes.
Yeah, Lordship, so far recruitment rules of estimator and surveyor is concerned, it's not before us, Lordship. And these rules is about the Lordship, this Onece Pradesh staff selection board rules.
The group C, group C post.
No,
You
no.
go to the steps.
This relaxation is talks about the relaxations of these very rules, Lordship. The staff selection board rules itself, Lordship.
Yes, it includes the power is to recruitment is to be conducted by a board for the post, group C post.
In that rules, Lordship, in that rules of the surveyor and rules of the junior estimator, Lordship, the separate rules are there, Lordship.
Where it is.
No, this is not before us.
No, my lord.
Just I'm making a small correction.
No, now this is, they may have some rules earlier,
Lordship.
but then rule has been framed.
No, these rules, if Lordship see the page 55, I'm just correcting Lordship.
Hmm.
Page 55. This is the rules, Lordship. These rules may be called Onece Pradesh Staff Selection Board Rules Act. Rules to the 18 laws.
Hmm.
These rules is governing the staff selection board for recruitment of this Lordship post only, Lordship, various posts. This is a guiding Lordship rules for the APSSB only, staff selection board only.
Hmm.
This doesn't rules govern the Lordship, the very Lordship, the post. The post has its own recruitment rule, Lordship, like JE has, Lordship. If Lordship sees the rules, Lordship, it's at 2N.
Hmm.
At page 55, Lordship.
55.
55 of the read petition, Lordship. What I'm pointing out, Lordship. This has been rules framed under invoking sections 22 of the Onece Pradesh Staff Selection Board
No,
Act.
that's what I'm saying. I didn't say that the rules regulating, I didn't say. I said rules, staff selection, Arunachal Pradesh Staff Selection Board Rules 2018. I said so.
Lordship, what I'm pointing out, Lordship. These rules is applicable for the staff selection board only, Lordship. While Lordship conducting examination, Lordship. This does not apply to the post, Lordship. Suppose it's junior estimated, Lordship. It has its own recruitment rules, Lordship. That's what I'm relaxing is report about these rules itself, Lordship. Not the recruitment rule of the junior estimator or surveyor, Lordship. Just I'm
Recruitment rule of junior estimator, I also have enclosed, my lord, in page number, my additional epidemic, page number 20, my lord. The rule is also 6, my lord, page number 20, my lord, power to relax, my lord. Surveyor also is there, my lord.
Then in that case, not this power to relax. Not first one, recruitment rule of junior. Rule 6. And you delete this last one, Arunachal Pradesh Staff Selection Board. Then what was that rules?
Junior estimator at page number 40 of my edition, or 20 of my additional epidemic, my lord.
And then
And for
surveyor?
surveyor, my lord, at page
what
number,
are the rules?
rule, my lord, at page number 12, my lord, type out.
It's
Power-
very difficult. It's just the running page. There are so many additional affidavit.
Yes, ma'am, sorry.
Why running page has not been given here? Once they file this thing? Once they file the complete the thing, running page has to be given. Tell them. Oops. Where is that?
Additional epidemic, my lord. Page number, annexure number 2, page number 8, type out is page number 12, my lord. This is pertaining to surveyor, my lord. Page number 12. Type out, power to relax 5, my lord.
Rule 5 and 5 of recruitment rules 1984. What is this? Page 12.
12, my lord.
The recruitment rules of See, this is also 6, power to relax.
Here 5, my lord. At next, it is 6, my lord.
Yeah, 5, 5,
Four-
6,
No, sir.
and then
For survey,
for junior estimator,
junior estimator, it
It's
is
at page 20, Lordship.
20, it is
Page
rule
20,
6.
Lordship. Here the power is at 6, Lordship. Power to relate 6. And these rules
rules 5 and 6, huh? Of the, then this is again rule 6, huh?
Rule 6.
Rule 6, Lordship.
Rule 5 and 6 of the recruitment of junior engineer, so and so 1994, huh? Recruitment code. Then common recruitment rule, the post of, it is draftsman.
Lordship,
Draftsman.
this page 20 is of draftsman, Lordship.
That's why, my lord, I have
Draftsman grade 3. Earlier it was a draftsman grade 3. Now it's a junior estimator, Lordship.
junior.
And so far, if
And rule
page 12 is concerned, Lordship, here, Lordship, is not clear
common
exactly. Lordship.
recruitment rules of the post of draftsman, grade 3. Put it within bracket, now designate a junior estimator. Provides for relaxation of rules. The authorities has not invoked the said rules, therefore, without invoking the power to relax, the provision of relaxation of rules, no recruitment appointment can be made. That's all. Next, Mr. S. Tapin Leonard, counsel for the petitioner. Leonard, senior government advocate for the state respondents. Submits that due to administrative exigency and want of manpower, the authority has decided to fill up the post on contractual basis for a period of 6 months on a consolidated fixed pay as the recruitment through the Public Service Commission, Arunachal Pradesh Public Service Commission, and the staff selection, Arunachal Pradesh Staff Selection Board takes a considerable time to complete the recruitment process. Mr. He submits that as per the office memorandum, there is 17/10/1994 and
1994.
1994, huh? And where is the contractual in 2000?
20 April 2000.
20th April.
2000.
There's not 20th April. It's 5th May. Okay, 20/04/2000. Clearly provides that in an exceptional circumstances where it is felt absolutely necessary on the part of department to do so, and in the interest of public service, an appointment to the post on contract basis is permitted. Listen. He submits that the authority has there is no bar in appointing the filling of the post in the exigency of service and for a period of, for limited period. Mr. The appointments are not made on regular basis, but only for a certain period. Mr. Therefore, no, Mr. Next one. He submits that though it is the advertisement, the post are sought to be filled up on contractual basis for a limited period of 6 months through walk-in interview, the petitioners may also apply for the same, and the same yardstick will be applied to all the candidates who appeared for the interview. There's no reason to doubt that there would not be a transparency. The issuance of advertisements itself shows the bona fide and transparency in the process of appointment, which is absolutely necessary as the regular process of recruitment is taking a considerable time. Mr. Where is that your letter? He points out that the department has written a letter today.
Additional affidavit also on dated 29.
That is the again problem. Another affidavit, additional affidavit. Why are one brought on main affidavit? Where it is?
Page 21.
21.
Yes, Lordship. Page 21 is dated 29 July 2022. This is before the Public Service Commission.
29 July. He refers to the letter written by the Joint Secretary WRD from a government of Arunachal Pradesh to the Secretary Arunachal Pradesh Public Service Commission as well as Arunachal Pradesh Staff Selection Board. Requesting to furnish the status of recruitment process against the post which were requisition. What was requisition? Which was requisition? Which was requisition by the department for selection. In terms of the rules, applicable rules. However, isn't that the recruitment could not be completed? You have no reply.
No update. Today, Lordship, I have spoken to the officer, and yes, they have not yet.
And they are yet to receive any response from the commission and the board. Mr. Considering no, he submits that in the effects and circumstances, due to shortage of manpower in the department, the department has the authorities have decided to recruit when appoint the post by the present advertisement for a limited period on contractual basis. If the petitioners are also eligible to participate, there is no bar for the petitioners to apply and participate in the recruitment process to work in interview. Due consideration will extend to no, then in that the Mr. S. Tapit, learned counsel for the petitioner, learned senior government advocate has placed on Reliance the following judgment: AR 1953, SC 250, 1997, 4 SCC 348. First one is para 11, second one is para 9, and 2006 11 SCC 731, para 75, 81, 82, right? Then only you take the name of those. Do you have the printed copy? Yes, sir. If you have, get it Xerox and put it in the file. The next step. The post of junior engineer is a Group B post, Group B non-gazetted post. And the other two posts of surveyor and junior estimator are Group C. Undisputedly, these posts are to be filled up through Arunachal Pradesh Public Service Commission and Arunachal Pradesh Staff Selection Board. As per the recruitment rule, recruitment for this post are to be through written examination and written exam followed by Bible procedure. The impune advertisement, the authority has, respondent authority has issued an advertisement, impune advertisement dated 20/08/2021, inviting application for filling up the said post for a period of 6 months to working in interview on consolidated salary of rupees 20,000 and rupees 15,000 respectively. By an addendum dated 24/08/2021, the number of posts have been provided as 7 for junior engineers, 4 for surveyor, and 2 for junior estimator. Next page. it is noticed that the state of Arunachal Pradesh, no, government of Arunachal Pradesh, by its notification dated 0407/2017, has authorized the Arunachal Pradesh Public Service Commission to conduct the recruitment of all Group B non-gazetted posts under the government of Arunachal Pradesh. Mr. The recruitment of candidates will be made through a written examination and personal interview conducted by Arunachal Pradesh Public Service Commission. Mr. The recruitment will also, no, Mr. The next paragraph. Next paragraph. Continue, please. On the enactment of Arunachal Pradesh State Selection Board Act 2018, all the posts of Group C are to be recruited through the said board. Mr. Because Section 4 of Arunachal Pradesh Staff Selection Board Act 2018. In that case, you as APPSC, herein referred to as so and so, short, and the APSSB, that should be in short in all the. Provides that notwithstanding anything contained in any other law for the time being in force, or rules or regulation or bylaws framed thereunder, relating to appointment to the services public post in a condition of service of employees of the government departments and other institutions established and constituted by the government and semi-government organization. The board shall be the authority competent to conduct examination for appointment to the subordinate services public post of such government departments, organization, and autonomous bodies and semi-government organization, if it's, and it shall be the duty of the board to conduct such exams. If you have any confusion, page 51. On reading of the above provision, it is the only board, it is the board APPSC, APSSB, who shall with the competent authority conduct the examination for appointment to the post, the Group C post, into the Group C post. Next period. The Group B non-gazetted post. Group B within bracket non-gazetted post, which includes the junior engineer, has also been authorized to be has also been authorized. No, for recruitment. Sorry, for recruitment to the post of recruitment of all the group B within bracket non-gazetted bracket close post and the government of mutual condition. The APSC has been authorized and are being conducted by them. The next paragraph. There will not be any dispute as regards such conduct of recruitment for the post of junior engineer, surveyor, and junior estimated to be thoroughly by the APPSC and the APSSB. It is also taken note that the department has also sent the requisition when long back requisition for recruitment of the present post of JE, surveyor and junior estimate to the APPSC and APSSB. In the year 2000, by letter dated, which date? 22
July.
29/07/2022. It is. The respondent authority has sought for the status, requested for status of the recruitment, which the petitioner is yet to receive. Yet to receive the response list of. No, not plus stop, comma, which indicates that the post of junior engineers, comma, surveyor and junior estimator are yet to be the recruitment process of so and so, post of so and so are yet to be completed. Next. No doubt the authority may have a power to appoint a person and eligible candidates to a post for a limited period on contract basis in the interest of public service until the recruitment process by the recruiting agency is completed. It doesn't give an authority to recruit by recruit without following the applicable recruitment rules. The recruitment rules, as noted above, regulating the appointment of junior engineers, the surveyor and junior estimate, provides for a written test followed by version. Therefore, by the impugn order, by impugn advertisement dated 21/08/2021, is it? An addendum dated 24/08/2021 for filling up of the post of junior engineers. Junior engineer, surveyor and junior estimate only through walk-in interview. Would not be permissible. Would not would be a not proper course of not proper course to be adopted for filling up even for a short period or for a limited period on contractual basis in the exigency of service. In my considered view, even for filling up the post for a limited duration and on contractual basis in the interest of public or administrative exigency, the requirement of a rule recruitment has to be followed in letter and spirit. Since there's no, only since the advertisement dated 20/08/2021 provides only through working in interview without there being any requirement of written examination followed by as required by the recruitment rule applicable recruitment rules. Same is not sustainable. We will get something in view of what has been discussed here in some of the considered with the decision to the advertisement inviting application for filling up the post on contractual basis for a period of 6 months through interview is not in accordance with the applicable recruitment rules and the notifications. Is not sustainable. That's the advertisement, Indian advertisement so and so 20/08/2021 and the addendum so and so 24/08/2020 are read by set aside and cost. However, accordingly, the Great President stands allowed and disposed of list of no order is proposed. Next para. However, setting aside of the advertisement and the impugn advertisement. Now, however, it is provided that it is, however, liberty is granted to the respondent authorities to fill up the post if what is that exigency if the contractual appointment on contractual basis is required to be made in exceptional circumstances and absolutely necessary in the interest of public service in accordance with the applicable rules and notification holding the field and as may be permissible under the law. That's all. Only liberty has been given. Exceptional and absolutely necessary situation in accordance with the applicable rules and notification and as may be permissible under the law.
Hambini.